Good afternoon, friends. I, on behalf of Export Promotion Council for Handicrafts, welcome you all to today's webinar on intellectual property rights and launch of design register. Today we have with us our guest faculty and prominent exporters and buying representative from across the country to guide us through this topic. This webinar will provide you with an introduction to basic concepts and definitions of intellectual property and intellectual property rights. Additionally, participants will be given a first overview of best practices, processes, and strategies related to IP rights enforcement, management, and commercialization. Thereafter, we will also have a brief presentation on EPCH's new initiative, that is a design register, and it will be launched later in the program. To begin with, we have with us Shri Ravi K. Pasi, Chairman EPCH, Shri Rakesh Kumar, Director General EPCH, Shri Dalip Bad, representing Dalip Trading Company and member of Committee of Administration of EPCH, Ms. Ruma Malik, representing Messrs. Something Else, and she is also alumni of Parsons School of Design, Mr. Rajan Agrawal from Rajan Overseas, Muradabad, Ms. Nupur Batra from Accessories by Nupur, Delhi, Mr. Rahul Bharadwaj from RR Overseas, Delhi, and we also have with us Mr. R.K. Verma, Executive Director, EPCH. And last but not the least, our guest faculty of the day, Mr. Ankit Sahni. He's a lawyer, a cyber law expert, intellectual property expert, and has represented various clients in negotiating settlements through alternate dispute resolution and diverse IP disputes. Ankit is a winner of the International Client Choice Award 2017 in the trademarks category for India. He is also one of India's youngest to qualify Microsoft certified professionals. May I now request Mr. Ankit Sahni to make his presentation. Mr. Sahni, you can start with your presentation.
Thank you so much, Rajesh ji, and thank you to EPCH leadership to have invited me. It is my privilege and my pleasure to address all of you. Aside from the distinguished members of EPCH, all others who have joined us as attendees. My attempt will be in this 40-odd minute presentation to take you through basic concepts of intellectual property, as well as look at some of the best practices and strategies that we can use to make effective use of the laws and all options that are available to us to protect and enforce our rights. So I will now put my presentation, the first screen on display. I'll just take 1 minute to share my screen. Okay. Okay, is this visible to everybody?
Yes,
Yes.
Okay. So that's the title, broadly what we're going to cover. So it all begins with the IP chain of activities. So, if you look at a very high level, how IP fits into the larger scheme of business and things, it starts with creation. You're all creative people. So there is a lot of creativity. There's a lot of innovation that goes into first ideating what needs to be created as a product, what the market wants, and so on and so forth. The next step in this chain of activities is when we talk about how to protect the effort, the creativity that has gone into creating a product. So that is where protection and the larger role of intellectual property laws comes in. Then the next aspect, of course, is the reason why we all do business. It is to commercialize and essentially market our products and to gain. Basically maximize the gains that we can draw from our products, innovation. And the last aspect is also a very important aspect because we are a country of 138 crore people. There are bound to be people who are out there to copy the hard work, the innovation, the creativity that goes into creating some of the leading products that our members put out there. So enforcement of right becomes an equally important aspect. So moving on, intellectual property, we can divide it, at least for the purposes of today's discussion, broadly into these 6 parts. There is trademarks, there is patent, there is copyright, there's industrial designs, there's trade secrets or confidential information, and there is geographical indications. When we perceive IP, this is a question that I regularly get from clients. What is the best way to look at something which is intangible? So the best way to look at it is the same as any other property. If we would have any other asset, machinery or real estate or a car or anything of value. So the same way intellectual property is, it can be sold, it can be purchased, it can be licensed. It can be kept. This concept hasn't entered into India yet, but in the times to come, we expect RBI to make certain changes to the law, to the framework, and allow for intellectual property to be kept as collateral and security for financing. It can be assigned. So when you look at intellectual property, the best way to look at it is the same way as you would look at any other kind of property that you own. Moving on, the basic question is, why should I protect IP? Why should I be bothered about IP? So these are some of the broad advantages that you have. Of course, it helps in recognizing your ownership rights. Once you apply for an IP, you get a registration certificate. It bears your names and is proof of the fact that you own what has been created by you and what is registered. It increases competitive advantage. The more IP you have with you shows how innovation driven and essentially creativity driven your organization is. R&D, of course, again, it maximizes returns on investment. You can monetize your IP. At times you don't realize there is so much of IP that we are sitting on, and at times it may not fit into our business model or our scheme of things as you're doing today. But the IP which is lying around can also be monetized by licensing it to third parties who may be interested in it. So for that perspective, it's also important to protect your rights and make sure that they're recorded against you as owner. Then it establishes, registration establishes this as a means to pursue infringers. There are people who copy your designs. We keep hearing complaints from the larger handicraft industry and clients that we are fortunate to serve. Many of you who have come back to us over the years with issues where both parties outside India and inside India have copied designs and things that you create with your hard work. So it's an important means to pursue infringement and overall industrial growth, from that perspective. So this is broadly why everybody here today across all industries is talking about IP and why IP is important. So moving on to the legal framework again corresponds to each of the categories of rights. So there is a separate act for each of the categories of rights. There's a Trademarks Act, Patents Act, Designs Act, Copyright Act. There are various rules and regulations which form under each of these acts. Then there are international treaties, very important ones, and I will come back to some of them which are important for this discussion, which govern your rights, especially your rights when you export out of India. And then, of course, there is case law, there is public policy, and there is developments in common law. So moving on to the first portion of it, I've broadly divided it into two parts. There is trademarks in the first part, and then the larger part concerns copyright designs and geographical indications, which is more relevant to the discussion. So I will try to spend less time on trademarks, but trademarks being an important aspect of business, it's important for us to go through it. So when we talk about trademark, what basically is a trademark? So a trademark is anything that helps you distinguish your business from anybody else's. So it can be a word, it can be a symbol, it can be a slogan, it can be the shape of your product. If it's distinctive enough that people start recognizing one of your leading products, they see it and they know, oh, okay, so this is originated from XYZ export house. I know this product. That also qualifies to be a trademark. So as an example, as you all can see on the screen, a word mark would be anything which is a word. So it could be Toyota. From amongst the panelists, everybody is using different names. So for instance, for Mr. Bharadwaj, it could be RR Overseas, which could be his trading name or his trademark. For Ms. Batra, it could be A&B accessories by Nupur, ABN, I'm sorry, and so on and so forth. And then each of you all would have a symbol or a logo. So that would also qualify to be a trademark. Same way slogans such as, in this case, Nike slogan of just do it, or any other slogan would also qualify for protection as a trademark. The example for a 3D mark in this case, in the slide on your screen, is the shape of a bottle. This is, probably very easy to guess. This is a Coca-Cola bottle. And for over 100 years, Coca-Cola has maintained this shape across the world. So even if there's no Coca-Cola written, as you can see, many of us may have been able to recognize this as a Coca-Cola bottle. So again, this shape is very important, a very important category of registration as a trademark. Moving on, again, aside from trademarks, there are service marks. So several people in the services industry are also entitled to protection of the names of their businesses. So Amazon in e-commerce, or Vistara in airlines, aviation, or MasterCard in financial services, and so on. Then there are certain non-traditional marks which are protected in India as well as many parts of the world. There could be sound marks, which in case of the example on screen, when we see an MGM movie, there is a lion that roars, the screen opens with that. So that qualifies as a sound trademark. Color is, we all know Tiffany and Company, the famous jewelry and accessories business. They use a typical, sea green color, which is there on their box. So that color is trademark to them. Only they are entitled to use this color for their goods. Same way, there are fragrances that can be protected, not yet in India, but in various parts of the world, fragrances are protected. Then, shapes of buildings or motion marks. So the motion mark on the screen is a Lamborghini with its scissor-cut doors, and the way the doors open again, they qualify for what is called as a motion mark. Another motion mark, very famous example from India is a lot of us may have Alexa at home. So when we say, "Hey Alexa," the way the blue light goes around the Alexa device that we're using, that also has been applied for by Amazon as a motion mark. So moving on, again, different categories of marks. Every mark need not be denoting a certain business. There are marks which are collective marks. For example, the EPCH mark itself is a collective mark. It denotes an organization where reputed exporters of the country all unite for the same purpose. So the example on screen is the Rotary collective mark. Then there are certification marks that talk about qualities. So on screen is the ISI mark, we have ISO marks, and so on and so forth. Again, trademark and trading of business names. So for instance, Coca-Cola company would be the trading name, and Coca-Cola logo would be the trademark. So the law protects both aspects, the trading or business name of your company, as well as the specific brand name or logo that you're using. Both aspects are protected under law. The functions of a trademark we've already discussed. Largely, it's important to protect your trademark because, number one, it indicates the source of origin of the goods or services. It assures your consumers, your clients, of the quality of the goods, because when they see the logo, they get assurance that, well, this is a product that belongs to a particular house, and it comes with the quality assurance that is usually associated with it. It creates your business goodwill and brand awareness and visibility. So to that extent, a lot of us who have not formally protected our trademarks, it is strongly recommended that we all go ahead with protecting our trademarks for all of these purposes, and also for the purposes of preventing any third parties from causing any confusion in the market or cheating on your customers and taking away your business. So this is the last slide in the trademarks part. Then we'll move on to the larger part of how to protect the innovative or the creative element that goes into creating our products, our handicrafts. So this is just an icebreaker, largely to put across the point that having an important brand and having an effective brand trademark strategy can help you go a long way. Now, each of these examples on screen, there is no business name or trade name or trademark which is written the word, but the fact that each of these logos have created such a huge impact on our lives, of course, by following the large facets of strategy that we discuss, that without the names being there, probably most of us will be able to recognize many of these logos and be able to talk about them, and be able to identify what company it belongs to, simply because it speaks of the goodwill that is associated with the logos, and the recall value, which is another important aspect. So with this, I'll move on. There are certain more slides in case there is some more time. I will come back to specifics of good trademarks versus bad trademarks and so on and so forth. But for now, in the interest of time, I will go forward to the next section of our presentation, which covers copyrights, designs, and geographical indications. So copyright, what does copyright law say? What does it do? And what does it translate into for all of us who've tuned in and who are listening to this webinar? So at the very core of copyright law, when we start the discussion, what is important for us to see is the aspect that we have to see what is copyrightable under the scheme of copyright law globally, everywhere, and this is not just limited to India. What is protected is the expression of an idea, but not the idea itself. So what do we mean by the expression of an idea, not the idea itself? Is if you look at the beautiful elephant at the bottom of the screen right here. This is an example of Mysore inlay work, which incidentally is also a protected geographical indication. So when we look at the Mysore inlay work, now if we use this example to discuss what would copyright law exactly protect in this piece of handicraft, in this piece of art, you see the pattern which is there on the elephant. That pattern is unique, and by itself it qualifies to be an artistic work. It is a work of art which has been created by the artisans or by yourselves, by designers who have been employed by you in your businesses. So what copyright would give you protection over is the artwork itself, but not the idea of applying artwork in general over an elephant figure. So that is the part that we have to bear in mind. When we go ahead, file our copyright certificates, a lot of times what happens is we get questions from clients that, okay, boss, we got our copyrights registered, but now there's somebody who's also using, designs. The designs are dissimilar, but he's using designs on a certain ornament or a certain object that we were the first ones in the market to use design on. So to come back to the discussion again, the copyright registration will not give you monopoly over the idea of applying a design or an artistic work to an object. It will give you protection over the expression. So the expression in this case is the specific artwork that is adorned on the elephant. So if somebody else uses that artwork on another elephant, or say on a camel, or say on any other object, or uses something which is deceptively similar to or nearly identical to the artwork which is put on the elephant, that for sure is protected under your Copyright Act, under your copyright registration, and we can take action against such infringers. So with that, I hope the distinction, the concept which is at the core is clear. We move on to discuss what categories of rights or works, so to say, as they're described in the Copyright Act, are protected. So there are broadly four categories of works which are protected. There are literary works, there are dramatical works, there are musical works, and artistic works. So for the purposes of today's discussion, the most relevant work would be artistic works, for the reason that all the designs, all the creativity that goes into designing, whether it's carving out an object itself, a piece of handicraft, or it's about painting or printing something onto an article such as a pillow cover or bed sheet or a Christmas ornament or any other showpiece or a lamp or a lampshade. The millions of things that the esteemed members who have joined in today are dealing with in their respective areas and niches. Each of those works would qualify as an artistic work. A literary work largely would cover everything and anything which is in written form. So, for instance, in the classic parlance, books, description, or poem, or poetry, or any other kind of writing will be protected as literary copyright. Dramatical would be pieces of theater and drama which are performed. The part that pertains to performance that gets protected under dramatical work. Musical, again, the musical notes, the actual notes that comprise of the music itself, regardless of the performance, because performance right is a separate right. So these are broadly the four categories of rights. And then there are two secondary or subsequent categories of rights, which are made up of these primary categories of rights, which are sound recording in case of an audio or ebook, or in case of for instance, a song that gets recorded. So that qualifies as protection under sound recording. And then cinematograph film is movies or any shows that we watch on television or any YouTube videos, those will be protected as cinematograph film. So with this, I mean, what is important to see, who does the Copyright Act protect as the owner, or so to say, the author of a particular artistic work, and what happens when somebody, so I'm getting a few questions in here, but I think probably we can address the questions at the end of the session. I'm putting them aside for now. Thank you so much for sending in questions. So coming back to the question of the issue of who the author or the owner is. So in the first instance, the person who creates the piece of art, or whatever we're trying to protect as copyright, any handicraft, any object that we're selling, each of the categories of objects that we talked about, the author will be typically the person who has created it, designed it, and has put it into existence. Now, one question that comes is, for businesses, and a lot of us are larger businesses, what happens, with the ownership of copyright? Of course, I mean, you have artisans, you have designers, you have other people who are on rolls with you, or they are, employed with you as third-party consultants. But you want to make sure that whatever they create, they are being compensated for it in the terms of salary or some kind of retainership fee or consultancy fee. So you want to make sure that the ownership, the economic ownership, and the beneficial ownership is retained by your businesses. So in that sense, what the copyright law in India says is, typically in the absence of anything else, the author is the first owner. But in cases where somebody is employed, and by employment it means is on the rolls of your company, in such case, the employer, meaning your company, is presumed to be the author and the first owner. So even if your employment agreement doesn't contain an express clause, though it is highly recommended that an express clause be created and be put into your employment agreements with your employees, as well as your consultancy agreements with third-party consultants or retainers that you have. There is a clause that should very expressly, very clearly and unambiguously say that all IP that gets created should be vested in the employer, which is you, in return for compensation, of course, that you're paying to your employees. So this is how the concept of author is, and the concept of economic ownership and beneficial ownership under the Copyright Act. So with that, moving on to the next slide. We come to the tenure of protection. So fortunately, under Copyright Act, the tenure of protection is a very long one. So by default, it is the lifetime of the person, the human being that created the piece of art, his lifetime, and then after his death, another 60 years. So that's far more time than you need actually to monetize or commercialize a particular piece of art. Of course, there are pieces of art that become classics and they remain in demand for years and years to come. But a lifetime, another 60 years, is generally considered sufficient time of protection in terms of IP rights. Again, another important aspect is that copyright does not require mandatory registration. So while registration is advisable, and I will come back to why it is advisable, but there is no requirement to register it. This can also be important when you decide on which all pieces of art or handicraft you would like to invest into for protection as copyright, because there is a fee that you pay to the government, there is a fee that you pay to your lawyer to have these registered. So the way copyright law works again globally is that there are two important international conventions. The most important one is called the Berne Convention, and there is also the UCC Convention, to which most countries of the world, most major jurisdictions of the world are party, including India. So what the convention says is the moment a work comes into existence, any place in the world, it is rendered automatic protection across all the member countries that are signatory to the Berne Convention and the UCC Convention. So if you can prove that you created something, it was original, you put your hard work into it, and it is a product that your team has created, the moment it gets created, provided we have sufficient proof of the creation of such work, it will be protected and rendered protection across all countries who are member of the Berne Convention, which largely covers most major jurisdictions of the world. So this is an important point to bear, and then I'll come back to requirements of registration, why it's important. Moving on, one important concept again to understand is, one question that comes often from businesses is, when we file a copyright application, it is filed in a two-dimensional form. Sometimes it is a print or it is a 3D drawing of something, of an object, which is rendered in 2D for the purposes of applying for copyright. So the law makes it very clear to your advantage. The law says if you have a 2D rendition of a 3D object, or you have a 3D rendition of a 2D object, both ways it's protected. Meaning if you submit as subject matter of your copyright application, a two-dimensional rendition of a 3D object, and somebody uses that to create an actual 3D sculpture or an object or something, that also is prohibited under copyright law. And the reverse is also equally applicable. So you can't have an ornament or a statue or any other piece of art which is three-dimensional, and somebody clicking a picture of it and applying it as a pattern on their various products, on their bed sheets or cushions or whatever other products we all work with. So a 3D rendition of a 2D object or 2D rendition of a 3D object, both are covered under copyright law. The other important aspect to bear in mind is, while the four corners of your copyright application will largely be an artistic work, any adaptations of the artistic work are also covered. So when you apply for registration, let's say an embroidery which is done by artisans, and you apply for copyright registration, so any adaptations of that embroidery to another garment. So for instance, if the subject matter article on which you've put the embroidery, and you're basically in the business of, say, selling lehengas, which have embroidery on them, or selling shawls that have embroidery on them. If somebody uses the same embroidery, puts it on a cushion, puts it on a lampshade, puts it on a t-shirt, that would be considered as an adaptation of the copyright that is protected and registered in your favor, and therefore you will be able to take action against unlicensed adaptations of such copyrights that you own. So with this, we move on from copyright to the next part of law, which is industrial designs. Again, designs is a very interesting area of law, and more often than not, we get questions around whether to register a particular piece of art or handicraft as a design, or as a copyright? So I will try to answer that in the next two slides as to what will fall under design and what will fall under copyright. So if we go into the definition of industrial designs, the first point is to bear in mind that what is protected under designs law is the feature of the shape or configuration or pattern or ornament which is put on an object. So to give you an example, I've taken the liberty, my team took the liberty of going on the websites of some of the panelists today and borrowing these images from some of your websites. So if we look to the right, I believe this is Nupurji's is taken on Nupurji's website, one of the designs for a wallet, which is in picture. So when we look at this object right here, the two which are here. So what when we apply for a design protection for these, what will typically be protected will be both the shape of the object, if there is any uniqueness. So of course it has to qualify the benchmarks of being absolutely novel, unique, and new, not just in India, but globally. So, and globally, everywhere in the world, design law works the same way. Whoever applies for a design, much like a patent, it has to be new, it has to be novel across the world. It cannot be prior published or inspired by something else that exists somewhere else. So, assuming this, purse or this wallet has a unique shape, so the two aspects which will be protected if we apply for design registration of this wallet will be both the shape and the contours of this object being the wallet, as well as the design, which you can see the beautiful design that is embroidered on the front flap of the wallet. So again, going back to the definition, designs would be features of shape, configuration, as well as the pattern or ornament that goes into decorating such shape. The design must be applied to an article. So if there is a design which is just on a piece of paper, those will get rejected because they won't apply. They won't fall in the definition of what a design is required to be. The design has to be applied to an article. And when you apply for a design application, because of course there's no way at the moment to give a 3D rendition or a 3D photograph or a video of the object, what you're required to do is you're required to present top view, bottom view, left view, right view, and various other views that adequately sort of portray the object that you're trying to protect as a design. So it must be applied to an article, whether in 2-dimension or in 3-dimension, and the design must be applied by an industrial process. So again, application by industrial process is a very important aspect of design law. If it is partially made by hand, that works, that is absolutely fine, but there has to be demonstration of some kind of industrial process. Now, in the past, there have been cases, judgments where things as simple as using a sewing machine or any other machine which helps artisans to create something which is semi-created by hand, semi-using the sewing machine or any other machinery, has been considered as an industrial process. So those will qualify as industrial processes. Other examples, as you can see on the screen, are a cushion with a pattern on it, beautiful pattern, which again we borrowed from one of the panelists' websites, as well as this, pardon me for my lack of knowledge and awareness, but it appears to be a candlelight holder, I think. So again, the shape, it does appear to be very unique. If it meets the criterion laid down for uniqueness and novelty, it will get protected as a registered design. Going to the next aspects of industrial designs, some of the other essentials that we have to qualify for the designs to get protected. Number one, it has to be new or original globally, as I spoke about. So which basically means it must not be prior published or disclosed. So a lot of times what we do is we have, each of us take out a catalog which is shared with our clients in advance of. So, for instance, if you're approaching the Christmas season, there are a lot of ornaments, a lot of exports that happen. It's a hot time for our industry to be active and export out of India. So what happens is a lot of times we would much ahead of when we are preparing or we've already manufactured something, we would share a catalog of all our products with our counterparts overseas or other places. Now that catalog, if it contains pictures, which it does, of our products, would amount to prior publication or disclosure for the meaning for the purposes of meaning under the industrial designs law. So the right strategy to follow here is, and I will come back to best practices again. There is a portion in my presentation at the end where I address some of the commonly encountered questions, FAQs, and best practices. So it's very important for you to have an IP policy. And by an IP policy, it need not, I don't mean something overly complicated, but something as simple as an SOP, a standard operating protocol for your designs team and your publication or marketing team to follow, all of you all to follow. So typically what we advise clients is, before anything is disclosed or leaves the four corners of your office, for the items that you're interested in protecting as a design, those must first be shared with your lawyer and applied for. So the day your design applications are filed, because they take 6 to 8 months generally to register, so you don't have to wait for them to register, but the day they are applied for, the very next day you can go ahead and share these images with your clients or put them up on your website and your catalog or whichever way. But if it is done the other way around, if it is disclosed first and you go on to file an application for design, if it gets registered also, it will be open to challenge and cancellation later on because it doesn't fulfill the requirement that is there in the law. The second point on this slide, which is again important for us to consider, is the fact that only the aesthetic aspect of design is protected, not the functional aspect. So the classic example is, if you look at a pen, now we'll see in the pens industry there are several pens that have very beautifully decorated caps, or the caps would have the metal part which would help you make it stand in on a pocket or somewhere else. So the functional aspect, or if you have a look at the grip, so each pen will have a grip. So there would be a pattern which is put on the grip. So now those aspects are aspects which are functional, because the grip is there to obviously improve friction and help you write better smoothly. The pin clip, no matter how beautifully it is decorated, would still largely as a clip would serve the purpose of having it put into a pocket and having it stay upright when you slide it in your pocket. So those aspects are functional aspects and will not be subject matter protection. Only the aesthetic or the creative aspects are protected under designs laws. The tenure of protection in designs laws is far less than copyright law. It's 10 years in the first instance, and you can renew it further by filing a renewal fee and renewal request for another 5 years. So it's 10 plus 5, 15 years in all. But the good thing with designs rights versus copyright is, copyright, there are far too many exceptions to infringement. If somebody is using it for teaching purposes, for research, there are dozens of exceptions, fair use exceptions to copyright infringement, which are not present in designs law. So to speak, designs law is a very strict liability sort of law in comparison to copyright law. So it gives you a more well-defined and a more solid right, which is why there is a shorter period of protection, whereas in copyright, there is, of course, a much longer period of protection that we just discussed. So another thing to bear in mind is, another distinction between copyright and designs is that while copyright, because of Berne Convention and UCC, is largely global in nature, industrial designs are territorial in nature. So in the past, whenever we've had the privilege of serving as lawyers to some of the members of EPCH, some of the challenges which we faced and questions which we faced are, I applied for a design registration, I have a certificate, I exported it to XYZ country, and now somebody in that country has started to copy the same design. But when my design is protected, why am I not being able to enforce my rights against, getting copied in another country to whom to where I'm exporting my goods? Now, there's a very important aspect to bear in mind. Each country has its own designs law. Design, unlike copyright, like I mentioned, is important. It relies solely on the disclosure that a particular applicant makes in their application. It is territorial in nature, and it is mandatory to register a design to claim statutory rights, legal rights. So therefore, as part of your larger IP strategy, what we recommend to clients is, if you're exporting to 10 territories, and out of 10 territories, let's say at least 5 of them are territories which are hotspots for infringement, or where you have encountered cases of people copying your designs in the past, it is strongly advisable that you register your design not just in India, but also in each of these territories. Now, the next question that comes is, how do I satisfy the requirement of novelty when I apply for a design today in India and I apply for it, let's say 2 weeks later in Germany? So there will always be a time gap in coordinating with the German council or asking my Indian council to reach out to somebody in Germany, sign the papers and file the application. So for that, there is another convention, another treaty called the Paris Convention, which allows you to, within a period of 6 months of your application in India, or whichever country your application originates in, within a period of 6 months, you are free to apply in any other country which is part of the Paris Convention, and have your rights equally protected in each of those countries as well. So that is how design rights work. One very important debate that has gone on for several years now in the Indian legal system, and some of our members have also been witness to, and in one such example that I can recall off the top of my head, also party to a litigation, has been the design versus copyright debate. Now, there is a very interesting provision in copyright law which says as follows. It's on the screen. Basically, it says that wherever there is an artistic work, which is, and this is basically the provision that talks about how to reconcile the seeming overlap that happens between design rights on one hand and copyright on the other hand. So the provision says wherever there is copyright in a design, there's an artistic work and there's copyright in a design that is capable of being protected under the Designs Act. So if there was some design which you could have applied for and protected under the Designs Act, but you did not because you could not act in time, you had to launch it and you could not contact your lawyer to file a designs application, and public disclosure was made, or it was published in a seminar, in an exhibition or somewhere, what do you do in that case? So there is a provision that says that in case there was such a artistic work which was subject matter of otherwise a design application which you could not apply for, the copyright in that, because once you don't see how it works, is there are two sort of bowls. The higher bowl or the higher trough is the design trough, into which we always advise our clients to file the applications, because that's a greater category of sort of right. It's a more well-defined and more solid right. As I discussed, very few exceptions to infringement, whereas copyright is a more broader right, and it is the default category of right where you don't fit into any other category. You by default can qualify as get protection under Copyright Act. So what happens is, if you miss the opportunity of getting protection under Designs Act, you by default fall into the Copyright Act bucket. But Section 15 says you will not be entitled to protect your copyright in that artistic work after you have manufactured more than 50 copies of any article where that design is printed or put upon. But the rider to that condition is that it must be done through an industrial process. So I'll give you a quick example. If we go back to this pillow here, I would assume that this is done by machine, the work which has been done. Now, assuming that the owner of this design did not apply for a designs registration within time, this one, and has to now seek protection for this design, this pattern under Copyright Act. So what the Copyright Act says is that he will not be entitled to protect it if he makes more than 50 copies of this cushion with this design using an industrial process. So by this, what is protected is if there is anything which is being done by hand, that is no problem at all. Anything done by hand, you can make 100 copies, you can make 200 copies, there is no restriction and your copyright will continue to be protected. But if you make more than 50 copies of something which could have been a design, but you did not apply for design at the right time, you're only entitled to protection till the 50th copy, after which the rights in your said design will lapse. So this is what the provision basically says. And again, moving on, this is an interesting case, real life case from the Bombay High Court to illustrate how design law works. So basically, this is between two companies, Cello, which is a popular company that manufactures plastics and other basically containers, bottles, tiffins, and so on and so forth, plastic products, and another company called Modware, who's the defendant in this case. So you will see the two competing products on the screen. So you see, Cello had protected for the bottle on the left, which it owns as a design. So by virtue of the designs law and the design application that they had filed, they had protected both the shape of the bottle and the way the color appears, the way the neck is purple, and then there is this white portion between, and then again it's purple right here with this oval shape right here. So this entire thing was protected and registered as a design that belonged to Cello, which got copied by the defendant, and the Bombay High Court in this case granted injunction and damages to Cello in favor of Cello against such defendant. So this is a real life example, a case study of how these rights have been essentially exploited and enforced at various forums. In this case, is the Bombay High Court. Moving on to geographical indications, again, a very interesting category of right. With geographical indications, what is intended to be protected is the fact that if there is a particular good which originates from a particular geographical area in India or anywhere in the world, and there must be something special about something that originates from that area. For instance, there are a few examples which are mentioned on the screen. There is Kanchipuram silk. So everybody knows Kanchipuram silk is very popular. The quality of silk which is produced in Kanchipuram by people who rear silk is of top-notch quality, has always been traditionally of top-notch quality. And therefore, if it originates from Kanchipuram, it is protected as, something which we are referring to as geographical indication as a separate category of right. Similar examples are Pashmina from Kashmir. There is Channapatna toys that some of you may be exporting, so on and so forth. So these are various categories of rights which are there. There is, of course, also Mysore inlay work, which we saw earlier during the presentation, the elephant with the inlay work in between. So each of those are ones that qualify the definition of something that originates from a particular geographical area traditionally, and therefore merits protection under law. The tenure for protection under GI law is essentially 10 years. It can also be renewed further. There is a huge campaign that Government of India through Ministry of Commerce recently ran to promote geographical indications. There is a label that they released on license, royalty-free license, so everybody who's engaged in sourcing their products from artisans which fall under any of these GI areas or categories of work. Moving on, let's see who can apply for registration. So typically, if you qualify to be any association of persons producers, artisans, or any other body which effectively represents the rights of people who contribute to the making of these handicrafts, you know. So for instance, in case of Pashmina, if there is an association of Pashmina artisans, that association can apply. No individual can apply, but that association can apply for registration of that GI. Once they are given a monopoly over that GI, they can further license it to their members. And whoever becomes a member of that association will be entitled to call their goods. And of course, they have to strictly conform to the conditions that are provided by the GI office, which is also part of the Ministry of Commerce, part of the IP office in India. So it cannot be that if you're doing Pashmina work elsewhere, let's say if you're doing Pashmina work in Ludhiana, you can call it Kashmiri Pashmina, or if you're doing inlay work in Delhi or Faridabad, you can call it Mysore inlay work. You will have to do it in that region. Ingredients or anything else which is specific to that region, input materials, raw materials, etc., which is specific to that region, will have to be there and present for somebody to be able to legitimately utilize the geographical indication. So this is an overview of GI, another important aspect of IP laws. Now moving on to some best practices, and with this we'll end this part of the presentation. We'll move on to the last part, which talks about enforcement of your rights through litigation, through courts, and through filing complaints before the police. So best practices. There's some to-do points, some things that I'm putting on the table, and hoping that, you know, at the end of the session we can make it more interactive, get more views, and happy to hear other panelists, experts, the kind of best practices they're deploying to protect and enforce their IP rights. So the first point on the screen is providing for confidentiality, non-compete and non-solicit clauses under your employment agreements, as well as under your third-party contracts, whether they are contracts with consultants, whether they are contracts with artisans, they are contracts with any outsourced manufacturers who are getting exposed to our blueprints and our designs. Because a lot of times we realize when we come across, we represent clients in matters, the source from where these designs are leaked are these categories of people. So you have to be sure that there is a confidentiality clause. We have to be sure there is a non-compete clause, where if you're entering into an agreement with an employee, we to a reasonable extent include clauses that limit his participation in a competing business, or basically prohibits him from doing work for any competing business during the course of his employment, and to a reasonable extent after his employment is terminated, so that confidential information, know-how is not leaked from your firm, your business, to other competitors. Same with non-solicitation clause. You don't want managers and people, teams leaving from your organization. Usually what happens is, if a team leaves, they would get the people who work under them also to follow. So if there is a non-solicitation clause under the employment agreements, that risk is covered to some extent, and we are protected. Then it's very important, as I discussed previously, to have, if nothing else, a basic IP policy and a standard operating procedure protocol for the teams to have in place. How to disclose creativity, who to disclose it to, not disclose it beyond the limited set of people who are supposed to know about something, till it translates or becomes or transforms into a product which you're going to market and commercialize. So controlling access to know-how while it's being created, revealing it at the right time to your lawyers, reaching out to your lawyers, so that we don't get hit by the novelty requirement under designs law, and we come out of purview of designs law. So making sure we reach out to the lawyer at the right time for our applications to be filed at the right time in the right place. Then again, some cases in the past that have taught us that sometimes there are clients that request you. There are overseas clients that request you to manufacture products. They provide designs to you. They are bespoke designs, customized designs, and you're required to apply those designs or that artwork and basically create a certain quantity of products and export it to your client overseas. So what happens is, while doing that, there's only limited due diligence that you can do to check whether that design belongs to your client or not. If we don't do if we don't take precaution, we face the risk of having used somebody else's designs on the order of a client, having manufactured them and then potentially getting sued, because the act of manufacturing, the act of putting a design on a product does amount to infringement if we don't have rights to the design. So it is very important that when we negotiate our arrangements, our terms of contract with our clients, we agree to an indemnity provision. And always in writing, anything that goes on email may or may not always be admissible. It's always better to enter into a contract which is duly notarized and signed by respective parties. So an indemnity will ensure, and the way indemnity clauses are drafted by us lawyers is, we basically say that you as manufacturer will act on the instructions of the client, and you will in no case be liable for any consequences that arise out of any third party claiming their IP rights in the products that you've been ordered to manufacture by your clients. And in case such an eventuality happens, your clients agree to compensate you for the damages and the inconvenience which is caused to you. So that's again a best practice that we advise our clients to follow. Another example is, in all our invoices, at times, when the eventuality occurs, there's somebody who's copying our design or alleges that they are using our design from before than when we were using it. If they claim prior use of that design, you're left scratching your head as to how do you prove, how designs should be proved that you were the first ones to create it or use it, and not just create it and keep it in your office, but also use it commercially. So commercial use becomes very important. Proof of commercial use becomes very important. But as you can imagine, when we manufacture something, there's no record of what got manufactured. It's only referred to in article numbers that we accord to a particular product, model numbers, article numbers, and sometimes they get published in a trade journal or in a brochure that we have. Sometimes they don't. And when they are exported, the invoices, whenever we've come across invoices, they generally just contain reference to article numbers in the quantity. So one practice that you all can consider including is to include alongside the article number in your invoices a small picture of the actual article that got purchased, either whether it's on the work order or it's on the invoice or proof of delivery or wherever else, any document that proves that you put this into commercial use. If you start including a small screenshot of that article, that will go a long way into building evidence which can be used at a subsequent point in time to prove against an adversary that you were genuinely the first one to create this and you have been using this design since several years commercially. Moving on, again, another question is, now see, it's very difficult because it's also a budget question. IP strategy is a budget question to determine. Sorry, just give me a second. So that was my bell actually. That was Rajesh ji telling me I have to wrap up in the next couple of minutes. So yes, now this basically is the last couple of slides. Again, another best practice is, so the first question that comes to us is, okay, I've got 200 designs. Now, how many should I register? Because there is a fee that I have to pay to the government. There's a fee I have to pay to the lawyer. So sometimes you have to resort to cost-effective strategies, which may be unconventional, but they may, do the trick. So again, without disclosing names, A couple of members of EPCH for whom we've done this in the past. I have included a screenshot of their trademark registration, because trademark allows for three-dimensional trademarks to get registered. So what we did was, instead of registering a single trademark, we included several of these designs in a single application. So while it may not give protection in the way it is, filed, in the way it appears on the screen, it may not give protection over each of these designs. But what it does is it serves a very important purpose of putting a timestamp. And this timestamp, as you can see, is put by the Government of India, the organ of the Government of India being the IP office. So this timestamp at least proves that you did create this and were in the possession of these designs on a particular date. And this can also be effectively used by you as a tool to apply for and keep as proof for use in subsequent times. So with this, I'll basically move on to the next part, infringement and remedies. Okay, so in nature, we would call this a miracle. It's a pair of twins. And in IP law, we call it infringement. So, somebody copies your design, what remedies do you have? An quick overview of the remedies that we have. If our rights are registered, they're duly protected. As we discussed in all of the previous slides, you will be entitled to get an injunction, which you can effectively use to prevent a third party from using your design. You can seek damages for the damages that were, or the inconvenience that was caused to you because of the other party copying your IP. You can ask the court to order for search and seizure of that party's infringing articles, get a raid conducted at their warehouses and seize their infringing articles. You can ask the court to order for delivery up. You can ask the infringing party to render accounts, how much they've been earning on account of the counterfeiting that they've been doing, so on and so forth. So this is what the remedies look like. The last part is on commercialization. Some of this we've already discussed, but I think it's time for me to say thank you. Thanks for joining in, and I think we can take questions. If that's on the agenda or we have some more guests joining, I will hand it over to Rajesh ji to tell us what to do next.
Thank you, Ankit ji. Thank you very much for that very elaborate presentation. I hope your talk may have made us a little wiser as far as IPRs are concerned. Now, to move forward, we have an eminent panelist with us, and I would request Ruma Malik ji to begin with. I'll start with a lady, and since she is also a designer herself, I would request her to give her views on what is being said and how IPRs are relevant as far as handicrafts are concerned. Miss Ruma Malik, you have to unmute yourself.
Ravaji, I would also like to add about Rumaji that she is also a founder member of the Buying Agent Association, and she also represents a very large number of the buyers, overseas buyers in India. So she knows about both the perspective, the exporter perspective and also the buyer perspective. Rumaji, please brief. I think just the comments only on the presentation. Unmute yourself. Thank you.
Yes. Thank you, Rakeshji. Thank you for everybody to be here. Firstly, I'm speaking on with two shoes on, with two hats on. Like Rakeshji said, I am a designer from the Parsons School of Design. I am a buying agent. So there are three hats.
Rumaji,
which is a design specifically done by.
Rumaji, your voice is breaking. Please, your voice is breaking.
By that person.
Please.
There is also a larger product. For
Rumaji can't hear.
business.
Your voice is breaking and we
third
can't hear.
part is
Rumaji can't hear you. Can't hear you. Please, just your voice, please. Hello.
I have communicated this to her, and she is going to. There's some internet trouble.
So in the meantime,
Join us again.
go. Yeah.
Am I audible now, sir?
You are audible. some audible, but still voice is breaking. But you can go ahead now, right now. Okay, please.
Yeah.
Okay. Can everybody hear me?
Yeah, it's better,
Yes, we
but
can
still
hear you.
voice is breaking. It's better, much
Okay.
better. Yeah.
So there are three perspectives that I wish to talk about. A, as being a designer, I recognize the rights of a designer to have the product given to his name or earn out of that product. There is also a basic commercial product that all our vendor friends, our factories produce, which is what we call open designs. And the third part is what our clients bring to us. So there are three kinds of product we deal with. Infringement of a specific design made by a specific designer is one part. The larger part that our industry deals with is open design. What defines open design? Who first makes an open design, a traditional design? For example, there have been talks some years back about Basmati, the name Basmati being copyrighted. Can you copyright a name like Basmati? Number two, the paisley, the traditional Indian paisley, which was derived from the Ambi. European 18th century artists worked on it. Indian artists have worked on it with centuries, through centuries. Can we copyright a particular kind of a paisley? And the third part is if a client comes to us with design, how far can you do due diligence? Is it practically possible for each factory? Okay, we are buying agents. We can go to our clients and say, prove that this is your design. We might get our contracts cancelled. That's another matter. But yes, we can ask them that. But each factory, and there are thousands of factories, small, big, can they really go and ask a customer every time they're asked to make a design to prove the ownership of that design? We are in a commercial world. And number three, every time a product is seen at a trade fair, there are thousands and millions of products. Can a client practically ask for ownership of every piece they buy? So these are things that we have to think about as an industry. These are things that we have to look at from three perspectives. From the artist perspective, from a buying community's perspective, and from the vendors, from a factory perspective. As BAA, as the Buying Agents Association, that's my first and primary goal today, is to speak to our vendors and the vendor community that the first thing we need to do is to create an environment where most buyers will not copy your designs and you will not copy each other's designs. There are, as a designer, all I can tell you is there is no need. There are millions and millions and millions of products that you can create. There are millions and millions and millions of ideas that the human mind is capable of. There is no need to do something just because somebody else is doing it. We need to bring this environment of trust to our buyers. And if they see that from our vendor community, we hope, well, as buying agents, we definitely try and reduce possibilities where one vendor has his designs copied by another vendor. But we hope that the buyers too will recognize the need to make their own designs, to not copy each other, and to give us the growth that we need to be known. We are known all over the world as a creative industry. The Chinese are known as copiers. The Indians are known to be creators. Let us take that initiative. Let us be creative. There are millions of human ideas that have been here for centuries. Let us do our bit. Thank you.
Thank you, Rumaji. Thank you very much for those crisp comments on the subject. Now, may I request Mr. Rakesh Kumar, Director General EPCH, to speak on the subject. Mr. Kumar.
Yeah, good afternoon, friends. Thank you very much, Rumaji. Thank you, Ankit Sahni ji. And a big thanks to all the panelists, our very renowned people. They are sitting today with us as a panel. Uh, Friends, handicraft is a creative business, as Rumaji very rightly said, million of ideas, which require constant innovation, design and product development on the part of the exporter. He needs to constantly update his product portfolio so that he can be in synchronization with the current international trends and basically the requirement of the overseas buyers. And the two major issues that have been raised by Rumaji, we are here to those issues. We have to give the answer to those issues. And at the same time, the presentation by Ankit, which is really a beautiful presentation that in fact mentioned about all the various laws, patent laws, copyright act, and lot many other things that is available, at least as a law of the country and law, international law, both way. But the major issue is it possible for the handicraft fraternity that to produce a design every day, a new product every day, or maybe 20 or hundreds of products to be produced every day before a fair or before any event or before approaching his buyer, that to be every time patent, go for patent, copyright or register and go for such a big process. So we had some very bitter issues in the past. In fact, being in council, we come across a lot of issues of the uh, litigations, a lot of complaints, where we come to know that really this issue needs some kind of a resolution, and this need some kind of an attention for the betterment of the entire trade and industry. I would just give you some example. Uh, in one particular case, shipment of one of our exporter friend, I don't want to name, it was basically a lamp that was stopped at Mumbai port. We sought the help of Mr. Ajay Sahni, father of Mr. Ankit Sahni, being the very renowned lawyer, and we could ultimately succeed, but with a great difficulty, because this product was basically his own design, but unfortunately, the buyer, one of the buyer of another producer, he procured these same samples and he registered these sample in Germany. And thereafter, when the shipment was going just at the Mumbai port, one 40-footer container was issued a notice to the buyer, to the exporter, that if the shipment will land in the Germany, we will get it confiscated and will not allow you for a business, and also will claim a very huge sum of money as a claim. In another case, I'll tell you, where one of the exporter, through one very known buying house, got some order. This gentleman, with his artisans, along with his own in-house designer, he developed a set of samples, gave it to the buying house. Buying house got it approved, placed some orders. There was an order for around 4 or 5 containers. And once they stopped working with the buyer said, now you cannot produce any more quantity of the same product and cannot supply to any other buyer. The reason is, we have got this product registered in entire Europe. Very simple. The third case. In the third case, there was a very popular item. आप सब जानते होंगे, एक आइटम था जो लकड़ी में एक कीड़ा घूमता था, छोटा सा डिब्बी होती थी, बीटल बॉक्स बोलते थे उसको हम, और जैसे उसको खोलते थे 3-4-5 रुपए का बीटल बॉक्स होता था, अंदर उसके पैर हिलना शुरू हो जाते थे. So there was a order of 1 million beetle box with some exporter of Jaipur. He started exporting, and the moment one container landed in US, he got a notice from there that this item is already got copyright because the beetle box was prepared. This was done in Jaipur, and for many years this was being exported. Suddenly they said कि रोक दो, कोई shipment पर भेजना क्योंकि ये तो हमने भैया इसको register कराया होगा. And similar case was happened in Thailand, where around 70 pieces, different articles of popular products, these were also got registered over there in Thailand. So these were some of the cases. Now come from our exporter perspective. I'll tell you some of the examples of exporters. One of the exporter started crying on the very first day of the fair at Delhi Fair. He said, sir, the samples which I had exhibited in Ambiente 5 days ago, the same set of the sample is now being exhibited by 20 exporters. And what to do? I don't have any patent, I don't have any copyright, I don't have any register because I have only 300 samples being displayed by me. What to do? So he was crying. Another case, and that happened just a year before, where one exporter exhibited his fresh sample on the very first day at IIGF, and on the fourth day, because first day most of the buyers were attracted to his sample, they were queuing up there. The same sample was there in about 50 booths. Fourth day. So now tell me what to do. Should we go for the Patent Act and get the production for 60 years, 10 years, 5 years, or we should simply say that, okay, it is our fraternity, we should go for the best practices. We discussed these issues. In fact, today Ankit is with us, but Mr. Ajay Khanna is a very renowned personality in this field. And Mr. Ajay Khanna, father of Mr. Ankit Khanna. So when we discussed with, Mr. Ajay Sahni, not Khanna, Mr. Ajay Sahni, we discussed with him. And right now, the Ajay Sahni, Ankit Sahni just mentioned about the best practices. And you must have heard that the core issue is that I produced it and I have proof of it, of the production of this item. This is the bottom line in my case as a designer. This is the bottom line, that it is my own design, whether I am a designer or a craftsperson or an exporter. Now, where the production is required. If you say for every country, we need a separate registration, it is next to impossible. So where this production is required? First of all, the production is required within my own fraternity, amongst my exporters. When you say there are 100 of exporters, 3,250 exhibitors are there. So that means the production is required amongst my first competitor, not amongst the Chinese competitor. Chinese will come later, but first my own people will come. So when we discuss with Mr. Ajay Sahni, sorry, I'm sorry for wrongly spelling the name, he mentioned कि आप कोई ऐसा फॉर्मूला निकालिए जिसके चलते आप उसके जो आइटम बना हो उसको कहीं ना कहीं उसकी फोटोग्राफ प्रोड्यूस हो जाए, वो कहीं ऐसी जगह छप जाए किसी जगह पर, ताकि जब कभी भी कोई आए तो उसको दिखा सके कि साहब आपके आइटम के कमर्शियल यूज से पहले हम लोगों ने आइटम बनाया था, वहां उस मैगजीन में छपा था, कुछ मैगजीन निकालना शुरू कर दीजिए. लेकिन द वे राइट नाउ रूमा जी मेंशन, it is the exact position of the industry that in this industry, the position is that millions of the pieces are being produced by the people. So it is not possible that we have to go and get these registered in some court or other place of the law, or even get the photograph printed in any magazine. Otherwise, it would be very voluminous. And that was the reason we thought that why not we should have one system, the system that should be mandatory, applicable to all as a code of conduct of the industry. And this code of conduct has to be mandatory for everybody who is in this sector, who is in this entire industry. And that is the reason this design register, which is to be inaugurated today, is being introduced among us, you. Friends, we have spent about 18 months for preparation of this design register. We made it so simple so that most important is because there are 2-3 issues among us. First is that it should not be expensive. Second is the privacy. अगर आप उसकी कॉपी मुझे भी दें, कहीं ऐसा तो नहीं काउंसिल में आपने मुझे दी और उसके बाद में हमारे यहाँ आने के बाद में पता लगा कि फिर उसके बाद में कहीं ना कहीं उसकी प्राइवेसी आपके पास नहीं है. So today we have brought a kind of a online system, and this online system, even we do not have access to the server. Anyone who will get his design registered on this online system, he will get a PDF back with the date and the number of a design registration, and that will be valid subject to certain condition. That means he will first of all ensure that the design produced by him and no commercial pieces have been so far produced by them. So this is the first piece at all, and that has been basically registered. So it is very automatically, once it is registered as a first piece over there, then if has a PDF of that with the date and time, and that is only with him, at any point of dispute or a conflict, that time we have to make it a reference to that, and retrieval is to be done officially. And that point of a retrieval, then the second person, either he has a copy of that or he doesn't have a copy of that, we can make a proof that this design originates from the person who has got it registered in the design register. This is a very, very simple process, and the cost is nothing. It is only 10 rupees per design kind of a cost is there. And rest of the entire formality, whatever is in the Patent Act, whatever is in the Design Protection Act has been there, Design Registration Act. All those features are the part of the design register. So definitely we are going to include everything there as a solution to this particular method. One more thing I would like to specifically mention, that is it a law? No, we are not going to work under a law. I would like to make a very simple illustration to that. What is this? This is basically a kind of a Khap Panchayat. What do you mean by Khap Panchayat? Khap Panchayat is the one that is introduced by the fraternity. So here we are introducing it as a fraternity law. And this handicraft fraternity law will have to be same for everybody. And once anyone, suppose somebody is having this paper with him, and the very first day he is displaying his product, second day he will find somebody else is there with the, we can straight away go. Because we don't need the relief for 10 years or 60 years. We need the relief for 5 days. That's all. And if these 5 days are gone, then everything is gone. And I'm sure once this will start, people after 1 or 2 years, they themselves will have a fear कि भाई इसने बनाया है तो इसने रजिस्टर करा लिया होगा, तो मैं अगर लगा दूंगा तो मैं फिर फंस जाऊंगा. तो एक वो अननोन फियर उसके दिमाग में रहेगा कि कहीं ना कोई एक लॉ काम कर रहा है, कहीं ना कहीं एक आपस में सिस्टम काम कर रहा है, जिस सिस्टम के तहत उसने जो बनाया है उसके पास में उसके अपने राइट्स को बचाने के लिए कोई तलवार है. हो सकता है वो तलवार लोहे की ना हो, लेकिन लकड़ी की तलवार है उसके पास, और ऐसे में वो एक बेटर फुटिंग पे है. और अगर बायर भी आपका कभी आपका बायर भी उस पर क्लेम करता है, तो उसके साथ हम उस पीडीएफ और उस सिस्टम के साथ जा सकते हैं, क्योंकि पब्लिक डोमेन में सिस्टम एग्जिस्ट करेगा. और जो पब्लिक डोमेन में एक पूरी सिस्टम्स के साथ चीज चलती है, दैट इज ऑल्सो एक्सेप्टेबल इन एनी कोर्ट ऑफ लॉ. सो अगर कोई जाकर के आपके यहाँ रजिस्टर ना करके पेटेंट में रजिस्टर बाद में कराए, तो वो भी आप समझें उस पेटेंट के सिस्टम करने में एडमिसिबल नहीं होगा. हाँ, आपसे पहले किसी ने उस प्रोडक्ट को ऑलरेडी कॉपीराइट कराया हुआ है, तो डेफिनेटली कॉपीराइट विल ओवरराइड यू, क्योंकि डेफिनेटली आपसे पहले कराया है, तो वो उसके साथ में वो पॉसिबल होगा. इन केस somebody has already got it registered prior to you under a patent act or a copyright act, then definitely that product will have a overriding powers on the one which is done in our system. But if that has not been done over there, so they will not have a overriding power for that. So I hope that I am able to explain you. Later on, there will be a proper PowerPoint presentation. And now I request Mr. Rawat to please take it forward.
Thank you, sir. There's a lot of noise. There's a lot of noise. Can you hear me?
Rawatji, you are very clearly audible. I think
Yeah.
background would be somewhere noise at your
Ah,
end, but otherwise
no,
it's
it's not at
absolutely
my.
clean.
It's very clear.
Yeah, it's okay. Okay for us, Rawatji.
Sir,
Yeah, we are getting everything clear.
thank you very much, sir. Thank you for introducing us to the design register. Okay. Thank you, sir. Thank you very much for your introduction of the design register. Now, before I move on to the other panelists that we have with us, and to our designer, Mr. Sunil Kumar, and our technical consultant, Mr. Deepak Thakkar. Since it is a very, very auspicious occasion because we are introducing a new chapter in the history of EPCH, a new platform for our member exporters. We would like to begin with lighting of a lamp. I know physically it is not possible, but electronically, technically it is possible. So I would request Mr. Manish to, with the permission of the guests, that we light
Mr. Ravi Pasi to inaugurate.
I would request our chairman to permit us to light the ceremonial lamp first. Sir, with your permission, should we do that?
बिल्कुल बिल्कुल ये तो शुभ कार्य है बिल्कुल
Sir,
शुरू होना चाहिए
Manish. So we are facing certain technical glitch, but here we are.
आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्परब्रह्म दीपज्योतिर्जनार्दनः
Thank you, Manish. Thank you for the electronic lighting of the lamp. Now, with the permission of our chairman and the esteemed panelists that we have, can we inaugurate and launch the design register by cutting the ceremonial ribbon? Manish? We have with us our designer, Mr. Sunil Kumar, who has been associated with this project since the beginning, be it conceptualization of the project or having stakeholders consultations across the country. Now, may I now request Sunil to make a brief presentation on the subject, and then I would like to introduce Mr. Deepak Thakkar, who has been a technical consultant on the project, to supplement what Sunil has to say. Sunil, you can start your presentation.
Thank you, sir. A very good afternoon. I welcome all the dignitaries, panelists, and attendees in this webinar on intellectual property right and design register. I'm going to give a short presentation that why we actually felt the need of design register and why EPCH felt that export fraternity should need a design register and how it will help them. So let's start with the presentation. As we all know, perfecting the design is the first step towards product success for any company dealing in the field of product design and development. A massive amount of resources and time are spent in creating these designs so that these designs can stand out in the marketplace and can catch the eye of the buyers. Quite naturally, our exporter member would like these design rights to be protected so that their precious design and concepts are not stolen by the third parties. Even from time to time in our domestic as well as in our international affairs, we have observed that conflict arises in two parties because of the copying or plagiarism of the designs or the articles. So in the past, we were not having any effective tool or we can say platform to tackle these issues. And moreover, registering any design with design registration body is a time-taking process. As Ankit ji said, very clearly mentioned all the aspects regarding registration, trademark, design registration, copyrights. That it usually takes between 6 to 8 months. But in our export fraternity and export world, the design gets old by the season. Each day they produce, as our DG sir said, each day they produce hundreds of designs. So after consulting and after having a stakeholders consultation meeting with various of our members, legal entities, and various other related to the field of design and product development, we came with the concept of design register. So intellectual property right is the next thing, but I think this intellectual property rights has already been covered in great extent by Ankit ji. So I will not going to cover that. But basically, intellectual property is something which you create by your intellect. It gives you intellect by your mind. So design is also covered by intellectual property rights. So this is a very basic definition of design. So we will also skip this because this has already been covered by Ankit ji. So we will get to know about EPCH design register. What EPCH design register actually is, how it will function. So EPCH design register actually is an online software maintained by EPCH, where the sole objective of EPCH will be to create an awareness among its member exporters only. And this design register will be fully computerized and can be opened only during the conflict resolution process and even in the presence of both the parties and a committee called design register functioning committee. So the design register will be the prima facie evidence in any matter or in any conflict which arises during any international or national event. The design register at EPCH is totally separate and different from the registration of design by the Office of Controller General of Patents, Design and Trademark. Design registered at EPCH is only to facilitate their members, not for like general public. Your rights in design are recognized from the date and time of the application is filed. So sooner you will file the application, the better it will be for the concerned or particular organization. So the design which has already commercially exploited means to say which you have already exported to some country or domestically you have sold that design, that will be not eligible for registering in the design register. A computer generated acknowledgement slip will be given to the after the registration process is over, and it will be having a reference number. That reference number will your code for all future reference related to that particular registered design. So in case any conflict arises, so you will give that reference number to the design committee, and in the presence of both the parties, it will be opened, and in that we will see the whose party interest is vested in that design. So any item which has been earlier registered with any other organization like controller of design and patents will have to, that particular person will have to notify EPCS that this has been registered. After that, I am applying for registration. And the registration process will purely work on the process on which the normal registration process of design works. So the material of the end product on which design is used, shape and size of the products, color combination of the products. So these are the things on which pattern, configuration, ornamentation. Now the question arises: what benefits you will get after registering your design with design register? So the officially registering your design means that you are in a stronger position if the third party starts making or otherwise trading in a design that is similar to your own. A design or product registered under the design register at EPCA shall always have a prerogative, means right or exclusive privilege, to establish its claim during all activities or events of EPCH, whether in India or overseas, among EPCH members only. So registered design can be used to stop parallel production or parallel importation. So it always gives a USP to your business, as said already, that you will be have like it will create an image of your business in the mind of buyers, in the mind of your end users. Registering your designs with registrar of design is usually a tedious process, and it's a very lengthy process. So we try to come it with a very simpler platform and less expensive platform. It will acknowledge your design, and it will also protect and give recognition to intellectual property rights related to that designs. But the most and foremost important thing is, in case of any illegal display exhibit of design at the exhibition, EPCH shall assist the actual or real owner in all manners. Either like in that case, committee will work that the product will be removed from that fair, or until the conflict is resolved, that product will be on hold hold on display during those fairs. So and one more thing, we will maintain a complete confidentiality in relation to the application maintained by EPCH related to that design. So we recommend you should register your design in design register as soon as possible after finalizing the design, and certainly before you disclose the design to the others. We also recommend that you can file drawings of your articles that are as close possible to the actual article that you will be selling. So next question arises, who can apply? So our member exporters can apply. So our member exporters who is having a valid our registration number can apply. So there is a one-time registration fee of 1,000. After that, for each design, we will have 10 rupees. This is a very minimum amount for registering any designs, because as our DG said that each season we produce hundreds of design, 200 of design each day. So registering all the design with registrar is very tedious, and it's a very even financial loss to the particular organization. So we came with this very simple solution that the member sorry the member should not have any previous dues, or the application can be filed alone or by his duly authorized assignee members. So we have also safeguarded the right of our artisans. So we have not excluded artisans out of it. So even artisans can apply for their design, for registering their design under the design register of PPCA. The conditions for registering design for artisans are that artisans should have a valid artisan ID card number. Secondly, this does not guarantee them any membership of EPCA. Artisans having valid artisan ID card will have to submit a certificate of novelty from a EPCH member that this product is novel, this product is new, and this product is created by this particular artisans, and it has not been produced earlier in any form or in any matter by other artisans. So they have to submit a paper of novelty from a registered exporter with us. So how will design register function? So there will be design advisory committee and conflict resolution mechanism. So like well said phrase of our design register is like a half panchayat register of our EPCH community, and it will only act in case of conflict between two parties. The intention of design register is to give the real owner the right related to the design or the article. Like how Panchayat have set up people and laid rules for their smooth functioning, we have design register advisory committee. So the design register advisory committee will function for any conflict during any ongoing fair or you can say exhibition. So design register advisory committee decision will be final decision making body in case of any piracy or fraud activity or any conflict or let's say for an example someone complains about that my design has been copied, my design has been replicated by that particular organization. In that case, this design advisory committee will come in action, and in presence of both the parties, it will act. The decision of design register committee will be not be prejudiced, and it will act accordance with the laid rule by the design register manual. Actually, this is a short presentation. After that, when you will have an access of design register, you will get user manual where you can read all the related information with design register. The design register advisory committee will have all the rights to remove the exhibits or suspend the display of products during the fair or till the resolution of the dispute complaint by the appropriate body. So how we can file the application, how we can register our design on our design register. So these are the basic steps. The first time you need to fill a form of one-time membership form, which will cost you.
We can bring in Mr. Deepak Thakkar here.
Sure,
He's
sure.
the technical expert. He
Sure.
can guide us how to. Mr. Thakkar, are you there? Deepak ji?
I'm here, sir.
Yeah.
Good evening, everyone. Good evening, Chairman, sir. Good evening, Rakesh and Verma, sir. So I'll come straight on to the point. I'll share my screen and show you a glimpse of how the registration process and other activities would work. Though we have tried to cover most of the aspects in as simple and a user-friendly manner as possible, but we would love to have feedback from the fraternity once they start using it. Can you see my screen?
Yes, we can see. Yeah,
Great. So this is the kind of screen that you'll get to see when you once come on to the landing page of the design register, wherein the registration process will first have to be done up, and to remove two possibilities that the person who's coming on to register on the design register is a member of EPCH, and also that his current membership is renewed and he is like the valid member of the body at the moment. Whenever a person kind of registers and creates his ID, at the same time, whenever he logs in onto the ID, the system of design register will talk at the backend with the EPCH member registration software and pull out all the details to map out if the person who's logging into the system is valid or not. So once when I kind of start using this video, I will stop it at various intervals to explain what are the processes and the activities that we need to do. During the registration process, there is also going to be an online payment part of it, which is going to be different fee structure for the members and non-members. The non-members are the artisans and other design agencies who have been covered in the presentation earlier, but at the same time, their fees is different, and that would be moderated by the EPCH before they get to submit their designs and upload their designs on the design register. So once when you start the design process, the registration process, you will have your email ID and your password that has been allocated to you, or you'll be putting in your member number. And once when you put in your membership number along with the CAPTCHA code, you will be taken on to the next page. So this is how the registration page will pull out the details. So once when you've entered the membership page, once when you've entered your membership number, the software will talk at the back end with the membership details at EPCH server, pull out the information and display it in front of you. So here, the information that you can see like name, organization, company name, etc. is already here. The two other aspects that definitely needs to be covered are your GST number and your PAN number. So these are not with EPCH for any and every customer that we have. So we would need the GST and the PAN number also while registering on this particular system. You will have an option to change the email ID as well as the mobile number. So for example, if the company export house is a big export house, and if you don't feel that the owner or the person who's going to be responsible for it is not the same, then you can always use alternate number of your designer or any person who has been entitled to kind of go and upload the designs in the design register. You will also have basic facilities and other aspects available to you, which would also include the changing of the password or change of your mobile number, etc., which is being shown on how the software would look like once when you're trying to enter it into the system. Now I'll pause the system here and try and show you what the screen is for. So one, you have paid a membership fee while you were registering for it, which is like a one-time fee, and that's something which should not be charged to you ever again. Second fee comes in for every registration that you do. And to support that, we would have an online wallet facility. So the minimum amount that you can recharge your online wallet at Design Register is going to be for 1,000 rupees. For every registration, the fee as mentioned earlier is 10 rupees plus 18% GST, which comes to 11 rupees and 80 paisa. That gets deducted from your online wallet. So once when you start registering your designs on the software, you would definitely need an online wallet balance. So after registration, I would request that everybody can go on and charge money onto their online wallet before starting to register the designs on the software. Here you would have a complete statement available for your viewing and downloading at any given point of time, as it's shown in the picture. So this is the screen for the wallet balance. You can go and check out the design transactions. So here what you see are the design transactions, and you can see what were the monies that you had added. So if I look at that particular aspect, I had paid in 3,000 rupees at one date, 1,000 rupees on another date. So these are like the date wise. You will have the complete details available to you. And you would also get a GST enabled invoice whenever you're making any transaction onto the website. Now, this is how a transaction page would look like. So if this is like a case example that we've taken, and you'll get to see, you can download your invoices again if you need, and if you're missed out on, you can check out the invoice number, and you can also check the design number which has been allocated to you. Registration number also comes up on any and every page. Once when you have gone through this, you would also get to see that there are, like, when you have multiple designs or multiple transactions, you would have like different number of entries which are appearing on page. You can segregate the things date wise, or you could even look at the order number and download the particular invoice if you have forgotten or if you have misplaced the earlier invoice with you. You also have a facility of downloading the Excel file on the particular thing. Now, this is the most important part of your design register, wherein we are getting into how you would be registering a design. Now, as I explained earlier, we are talking about 2D, we are talking about 3D. There are multiple features and functionality. There are multiple detailing of any and every product that's needed to kind of ensure that, yes, the product which is being uploaded is unique. You would also have option of uploading pictures to it. And as Sunil mentioned, that you could even upload the hand drawings, which definitely has to have some bit of sizing along with it, which comes closer to the product that you're going to be manufacturing or making at the end of the day. One particular thing which I would want to mention here is that you can add multiple pictures of your product, but you will never be able to delete it. So if I want to call something like an Apple phone today, and tomorrow if I want to come back and change the pictures of the particular product that I registered, I will not have a functionality to remove the earlier pictures, though I would definitely have functionality of adding on more pictures to it as and when my product is taking more shape. So this is how you would be registering your details. You would be selecting what is the material that you want to plan and introduce in the final product. What is the shape of it? What is the dimensions, inputs, outputs of it? What are the colors needed for it? So it just show you a small example of how you can fill up the form. You have facility of putting in the dimensions in various units, starting from feet to centimeters to millimeters. you will have multiple. So if you can see that you have a plus arrow here, which means that if you are creating the same product in multiple dimensions, you can have multiple sizes that can be added over here. It's not a single size. You can even upload multiple sizes. So if you're creating identical product in 3 different sizes, you will have a feature and functionality to do it over here. Moving forward, you will definitely be selecting the colors that you want on it. What you're seeing now are, there are 2 particular instances which will come up in between, wherein you'll be talking about the novelty of the product and a declaration that you'll be making. So this is the format of the declaration, and this also covers, so the software has a lot of features and functionality which covers it from the patent design part of it, and also includes you into and covers the entire cyber security and cyber law part of it, which ensures that anything and everything that you're doing covers you legally also. Now, this is how you'd be uploading the pictures coming up on the screen. It will always bring you back to your page again and again till the time you're not filled in all the mandatory fields required to register your design. So the first one was NOC, and this is like novelty. The first one was the novelty. This is like the NOC that we have submitted and uploaded on the site. And we have uploaded a picture also for the demo purposes. This is the kind of screen that you'll get to see. So you have the application type, whether it was hard goods 3D or soft goods 2D. You have the date and time on which it was registered. The registration number also features and covers the date and time stamp of it. You will have the category under which you have submitted your form and the subcategory under which you have submitted the form. You have an option to view any and every registration which has been done by you, and you can update it also, or you can take a look at the PDF file that you have for it. So these are the features and functionality which are available on a page which is like the registered designs for you, wherein you can go and check out all the details and inputs that you have filled in. This is how the PDF file would look like. It's a soft copy, so you can even create, we can even give out facility of Zoom and other aspects. This is typically the screen wherein we said that you can upload multiple pictures of it. So first we had done up an entry for this particular product. Now we are back onto the product and we want to add more pictures to it. So if the first picture that you had created was a hand drawing, or it was a 3D picture that you had uploaded, which could be a CAD design, now you come back and you want to upload an actual photograph of the product, because those are the things which will help you eventually in case if there is a dispute with any of the fellow exporters. You will have 15 pictures then can be uploaded. So be wise when you are uploading the pictures. So it should not happen that once when your product was ready, you did not have an option of uploading more pictures. So the total number of pictures that can be uploaded on every certificate cannot exceed 15. So just be very, very cautious of what you're uploading here. You can delete or add the number of pictures that you're looking at uploading, and you can submit the file again, or you can just simply go back and update the other design or a particular product that you were looking at. This is how a certificate of that particular thing would look like. When was it registered? What did you do with it? What were the colors? So the entire details of it comes up on the PDF file that we are displaying to you on your screen. This includes the statement of novelty and the NOC plus the pictures that you had uploaded. So a thumbnail of it will definitely come up on your screen in a PDF format. Now coming on to a very interesting part of it, when we spoke about that on the first day we at the fair, we had a person who had created a new design, and on the fourth and the fifth day, there were multiple people who were showcasing the same design in their stalls. So now when the dispute committee, design committee comes into action, there are a few things that I would want to make clear here. One, that once you have uploaded the details of this particular software online, nobody would have access to the designs that you have submitted, to the tune of that even when one person, one exporter puts in a dispute against another exporter, still the people at the council would not have access to the designs to compare it at their end. So there is a dispute number which is allocated to the person who is filing in the dispute, which is not available and viewable to the council. They will not be able to check even the dispute till the time the person is not sharing the dispute ID with them. Second thing to be mentioned here is that you need at least 2 administrators simultaneously logging on to the system to verify after putting in the dispute number provided by the disputing party. Besides this, we have given you the basic terms and conditions and about us and other aspects of the presentation, which will make you pretty comfortable with the whole deal. I will stop sharing my certificate and talk a couple of more points related to it. Point number one that we all need to understand is that this entire design register is behind a SSL enabled server, wherein actionables would be that the to and fro data which is going to the server and coming out of the server are encrypted, so you cannot access the system and hack into the system. Second thing, which I earlier mentioned, I'm sorry I did not mention, but which needs to be highlighted is that this entire software, the front-end user items as well as the back-end items which are related to the administration of the entire software have been validated by a cyber security audit firm, which has gone through and audited the complete part of it, which took some bit of time for us to go back and forth and create a system which is more robust. So I would ask all the panelists to kind of come forward if they have any questions. Otherwise, I'll pass on it back to Mr. Rawat to take it forward.
Thank you, Sunil. Thank you, Deepak ji, for letting us know what design register is and how we can register our designs on the platform. Now we have a request from Ruma ji. She has to leave. So if she has another meeting, so she's going to leave us since she has already given her comments.
Ruma ji, one person from the Buying Agent Association would also be requested to be part of the complaint resolution committee, conflict resolution committee. So
Certainly,
I think
sir.
we are going to send you a request so that there should be a due presentation of all. If there's any issue on part of the buying houses, that would also
Absolutely,
be
sir. That will be a pleasure. That will be a pleasure.
I hope this is going to answer, design register is going to answer your later 2 questions you mentioned there.
So only one last thing before I sign off, and that is to protect our traditional design, our traditional work. So all the artisans who will come forward and all our traditional art which is there, I would like EPCH to take a look at that on how we can protect it, because we often have a situation where somebody or the other registers a traditional Sanganeri or a Bagru or a Kashmiri design, and then they have a patent on it. So there is a much larger issue which is there in today's world. But what EPCH has done today from BAA, from all the buying agents, we truly appreciate it, and thank you very much. for doing this for us.
I think, Romaji, before you leave, just I have to answer your question again.
Yes, sir.
See, this design register is certainly not going to cover the traditional design, but GI registration is covering all the traditional design. And so far, so on, 230I GI registrations have already been done. And many more are coming. Please let us know wherever you think that there is need to protect any geographical indications, any area, any design specific, or their production process, that we will cover under the GI process. Here in this design register, the bottom line is anything which has been earlier produced, commercially exploited, or exhibited anywhere, that is not covered. So
Correct.
anything which is produced today, I think that has to be instantly registered. That is the bottom line.
Absolutely.
Right?
This is a perfect way to start.
Yeah. Thank you very much, Rumaji. At least we have to start from somewhere. In
Thank you so
post-COVID-19, we have to do a lot of new things now.
Absolutely. Absolutely. Thank you, sir.
Okay.
And I'm available at any time for any help.
Thank you for your time. Thanks.
Thank you, sir. Thank you. Bye-bye, everybody.
Ravaji, please take forward.
Thank you.
We request the Dilip ji.
Yeah, thank you, Rumaji. Thank you very much. And now, before we move on to Mr. Dilip Baid, I would like to share with you that we have 7 member exporters from all across the country who are lined up, who have registered onto the design register, and we'll also ask them to join the panel. But we have to finish one round of discussion with the existing panelists. So may I now request Mr. Dilip Baid to share his views on what is being said on IPRs and the design register. Sir.
Okay, good afternoon, everyone. Do we have Ankit Sahni here? Mr. Ankit Sahni is here.
Ankit is still there.
Yes, please. Mr. Thakkar, I'm here.
Okay, Ankit, this is Dilip. I would like to know, for the benefit of all our members, this design registered, though we have been told that it may not be a legal thing, but how far can we go with this? When there is a dispute, when somebody takes us to a court, how far can we go with this design register in that?
Thank you so much, Dilip ji. So to answer the question in a very simple manner, I think most of the things that Rakesh ji talked about are very relevant. He put almost all caveats and disclaimers on record. But to give a high-level idea, rule number 1 is for any dispute to be privately negotiated, settled through the dispute resolution body, which has been formed under this great initiative. Participation is voluntary. So I understand what mandates a member to participate is when he signs up and creates an account, he essentially agrees to the terms of dispute resolution as well as the terms that govern this design register system, which EPCH has put in place. So by contract, he allows for this dispute resolution mechanism to essentially determine to some extent the outcome of a dispute that he may have with another fellow member. Of course, that's the main caveat here. This won't be against the world at large. Even when we look at arbitration law, for instance, any right which involves enforcing your rights against the world at large is excluded as subject matter of arbitration. Only disputes that are inter se parties, between parties who have agreed to have a body of people essentially mediate or arbitrate their dispute, it is binding on them to that extent. So I feel, one of the things that we have to correlate this to, Dilip ji, is the fact that I agree with the point, despite being a lawyer, that it's impossible to ask members to invest so much of money in getting every design, everything registered. So this becomes a very cost-effective and at the same time very efficient way of resolving disputes, as well as doing what is known as basically putting the hat over the over the hanky. A similar thing that another association has done. Of course, nothing as close to the system that I've for the first time seen with you all. The demo that Thakkarji gave us, fantastic system. Very simple, similar system has been adopted by the Scriptwriters Association in Mumbai over the titles of movies as well as plots of scripts which they do. So what happens is within the community, it becomes a very efficient way of dealing with disputes when one member says, no, I came up with this design first, and another one says, no, I came up with the design first. What will also help is the fact that, that the way the system is designed makes it absolutely confidential when somebody submits a design, and there is no central authority person or body that really this design gets disclosed to, and it will only come into the picture when and if something gets into a dispute. So to that extent, I think it will go a long way in effectively resolving disputes, at least as far as this large community of members of EPCH are concerned.
And how far, Ankit, can we go with our overseas buyers? I mean, with this, I mean, if somebody gets it copied somewhere in China, she takes this sample and gets it copied in China. How far does that support us?
So, Dilipji, with that question, the least we can prove, of course, is as far as Indian law is concerned, anything which is submitted on the design register will act as, it doesn't matter whether it has the backing of law today or not. You never know. I mean, maybe I'm thinking as a romanticist, but I would say if this is, and this must be highlighted as an initiative to the Ministry of Textiles as well as Ministry of Commerce that basically looks after IP rights. Who knows, this model is replicated across other industries and bodies as well. But to speak about it in in rudimentary terms, the least that it does, and that itself is a very important thing, is when a member goes on the register and records or lodges and uploads a design that belongs to them, it gets uploaded on the server of wherever the design register is being maintained, and it is time-stamped. That itself is very important proof of the existence or the creation and consequently the ownership of a particular design which belongs to the person who's claiming right over it. So it will be a very vital piece of evidence if we ever get into a contentious issue against, let's say, a Chinese player, provided, of course, these are matters of international law. If the matter is contested in India, for sure, courts will admit this as a piece of evidence.
Thank you, Ankit. So I can conclude that this will be a vital piece of proof wherever we go. Like, I mean, so that's it.
Very relevant, yes, absolutely.
I mean, to other panelists now.
Thank you, Dilipji. Just I would like to add that it is not only the persons who sign the design register, they will be part of it. As a matter of fact, EPCH has 11,000 member exporters, and the moment any person will sign up the membership, they will sign the membership, it will be part of the code of conduct of the membership. And even whose membership is to be renewed, now in the renewal itself, the code of conduct of this design process will be sent, whether he registers design or he doesn't register design. Suppose there is a case, one person says, okay, I have not registered a design, but the other person has registered the design. The person who has not registered the design, he says, I don't come under the purview of it. No, the moment he is member of the EPCH, he comes under the purview of that fraternity. That's why we call it a Kha Panchayat. So it becomes a rule for everybody, whosoever is in the fraternity. So this is the one major area of our concern. I would also like to say that the first mover approach in case of the election process by EPCH, we started the web election in the country very first time. And today it has been adopted by the Ministry of Corporate Affairs for all companies. In fact, we gave a presentation to Ministry of Corporate Affairs, and later on this web-based election was adopted by them. I hope that the same process will now be adopted by other organizations. Thank you very much. Thanks, Ankit ji. Thanks, Dilip ji. Rawat ji.
Thank you, sir. Thank you, Dilip ji. Thank you very much. I would like to move on to our other panelists now. I would request our chairman, Shri Ravi Pasi, to share his thoughts on the subject. Sir, you can unmute yourself. And meanwhile, I would also request Manish to get the other 7 exporters on board so that we can also have their thoughts on design register. Sir.
Good evening to everybody. आज जो ये सब्जेक्ट ये काफ़ी दिनों से हमारे प्रोसेस में था, राकेश जी ने इसमें बड़ी मेहनत की और भी जो साथ जुड़े हुए लोगों से उनसे काफ़ी एडवाइस ली, तो आज एक ऐसा दिन आ गया चाहे हम घरों में बैठे हैं मगर इसको अच्छी तरीके से 2-2.5 घंटे से सुन भी रहे हैं। ये एक ऐसा सब्जेक्ट है जो एक्सपोर्टर्स की, जो डिज़ाइन की कॉपी करने वालों के लिए थोड़ा सा एक ऐसा हथियार है कि आने वाले समय में ये काफ़ी फायदेमंद होगा। और मेरी ये रिक्वेस्ट है और मैं मुबारकबाद भी आज आपको देता हूं कि जिस दिन का हमें इंतज़ार था ये भी आज एक काम अच्छे दिन के अंदर हो गया। और अगर कोई क्वेश्चन आंसर हो तो अभी आप सब पैनलिस्ट और सभी से पूछ सकते हैं। रावत जी हैं, अपना राकेश जी हैं, वर्मा जी हैं और हमारे अपना लॉयर साहब हैं यहाँ पे सारे। और मैं इन चीज़ों के साथ अपना धन्यवाद करता हूँ। थैंक यू सो मच।
Thank you, sir. Thank you very much. Now we have another lady entrepreneur amongst us, Ms. Nupur Batra. I would request Nupur ji to share her thoughts on the subject. Nupur ji, you have to unmute yourself.
First, we forgot to congratulate EPCH. Thank you so much. Everybody tells me I'm very creative, but I think मैंने जो आज ये presentation देखी है, I think EPCH is amazingly creative. Doing a lamp and a ribbon cutting is amazing. Okay, I have been a designer for few years और मैंने अपने काफी designs अपने एक trademark भी करा हुआ है, patent भी किया हुआ है. मैं 2012 से जब मैंने शुरू किया था and I was doing the IPR and I got my trademark done and I got my designs done. It was taking a lot of time and a lot of, you know, somebody like us, like we are not as logically spaced out like what Ankit Sahni is. So, you know, एक design के बाद हमको 15 दिन में हम एक और design बना लेते थे. And then spending 20,000 rupees on one design. फिर हर तीसरे दिन के बाद spending another 20,000 on another design. It was actually pinching me as an entrepreneur because, you know, sometimes you don't earn that much of money by selling because some designs do well, some designs do not do well. So initially in my first year of work, I started doing a lot of patenting, a lot of copyright on my designs and all that. But eventually as I started working, what happened? 6 inch को 8 inch में कर देते थे. They used to say, this is not your design. So there was a lot of exercise, a lot of emotional pain, a lot of money loss and all that. But what EPCH has done is, I think they are giving diamonds at a price of peanuts, I guess. And Rakesh ji, I mean, this is amazing. I mean, you need to be very intelligent to come to this point. And I am really, I mean, from where did you get this? I don't know, but it's really nice. Somebody like me who's been working with the Indian craft for the last 10 years, you know, every time you go to the interiors of India, you go to Srinagar, you go to wherever, you go to Srinagar, you go to Bhopal and all that. There is so much of creativity in India. After the point of creativity, you really have to make money to survive for yourselves and your cardigans and all that. So this is where this exclusivity of creativity will get to the next level of design. And design का अगर थोड़ी सी ownership हमको मिल जाए, then we can actually approach as business houses. And then we can say, because, you know, at the end of the day, design world में सब सबको copy करता है. हमारी designer language में कहते हैं we get inspired by a Gucci or a Prada, but at the end of the day, everybody is making a black dress. कोई 6 inches बना रहा है, कोई 8 inches बना रहा है. So it is the creativity, yes, but design, when you register a design, the legality that comes in and which secures your business model is a great idea, I guess. And congratulations. Thank you.
Thank you, Nupur ji. Thank you very much for those encouraging, lovely words for EPCH and Rakesh ji. And to move forward, I would
Team is amazing.
It's team EPCH. It's not one person. It's team EPCH. Sunil, our designer, Amla, our Mr. Deepak Thapkar, Mr. R.K. Verma, Mr. Rawat, Manish. Everybody has worked very hard as a team, and I think they deserve great appreciation. Thank you very much. And most important, all of you. As a stakeholder, all of you are going to adopt it, and you are going to repose it, confidence and trust in this system. That is more important. Thank you. Rawatji, please proceed further.
Thank you, Nupurji. Thank you very much. Now, may I request Mr. Rahul Bharadwaj, who's amongst us, and he was in fact the first one to join the webinar today for the testing. And Mr. Bharadwaj.
Thank you, sir. Thank you, Rakeshji. Thank you, entire team. It was wonderful having such an amazing seminar, webinar, you call that. I really feel this will be a game changer because as a company, every year we used to spend $25,000 to $30,000 for the design, and we are participating in 3 shows. We have to keep our samples there. But the very next show when we came, like we have that items copy, and we can't blame anyone because then the only process is like that we need to again start working on new designs. Again, we have to invest such amount. So I'm really happy, and I really congratulate entire EPCS team for the launch of this design register. And I have one more thing to say, that if we get our product registered under your this design register, and we have the certificate of that, so we can keep those certificates at the show on those products. So I think that will be, the buyer have an idea that these are exclusively made by these vendors and these have already been registered in the EPCS. So they won't be looking for that items in other stores, and I think that will help us to grow our business and will help us and motivate us to make more designs, because you've seen our booth and we are generally working very, very hard on the design. And again, thank you very, very much, and congratulations again. Thank you.
Thank you, Rahulji. Thank you very much for that wonderful suggestion. We'll surely do something about it. Now we have with us Mr. Rajan Agrawal. Mr. Agrawal has been patiently listening to all the deliberation for last 2 hours. So, Mr. Agrawal, we would like to have your thoughts on the subject. Agrawal sahab, unmute kar lein aap.
Okay. Good afternoon, everyone. I am Rajan Agrawal from Rajan Overseas. I am in this field for last 30 years. जैसा कि मैंने सभी आप लोगों को सुना, और ये बहुत अच्छी अप्रोच है, और हमें इन डिजाइन रजिस्टर की तरफ बहुत ही जरूरी है कि जाने के लिए, जैसा कि मैं भी फील करता हूँ कि
यस सर, बताएं। ठीक है सर, बताएं सर।
साहब आप म्यूट कर लीजिए।
राजन जी कंटिन्यू करिए प्लीज।
राजन जी आप कंटिन्यू करें,
प्लीज कंटिन्यू करिए।
राकेश जी, जैसा भी कि मैं अपना भी उदाहरण देना चाहता हूँ कि हमने स्टार्टिंग में बहुत ही यूनिक है, जो कि वो वर्ल्ड मार्केट में भी नहीं थे। तो अगर वो उसकी जानकारी और ये प्लेटफॉर्म जब अगर होता तो ये उसका फायदा हम लोग आज भी ले रहे होते। तो उसके लिए आपको थैंकफुल कि हम हमेशा नए डिजाइन बनाते हैं और लोग कॉपी कर लेते हैं, और मतलब उसका नुकसान सभी को होता है। बस मैं यहाँ पे एक चीज पूछना चाहता हूँ राकेश, जैसे आपने कहा खाप पंचायत, ये 5 दिनों के लिए होगा?
नहीं, दिस इज फॉर एवर। राजन जी, एक बार जब डिजाइन रजिस्टर हो गया तो इसमें कोई लिमिटेशन नहीं है, 10 ईयर 60 ईयर की लिमिटेशन नहीं है, इसके अंदर में तो फॉर एवर है। डिजाइन हैज बीन प्रोड्यूस्ड बाय यू, and then this time you are the member of the EPCS, the other person is there, that will continue forever. 5 days EPCS fair means a demo is being created at that time. That is a particular time when everybody is bringing out his own design outside, so there it is visible, they are the buyers. But if you come to the notice of any member who is otherwise illegally doing the business, or who is doing business on your product, and you come to know, even at that gate also we can serve notice to them, and we can come forward for the help of the person who has registered a design. So certainly it is not only for an event, it is not event based, it is definitely for it is like a property of yours, it's your intellectual property registered as a design for the design protection of yours, it's your design protection forever. आप लोगों को जो बुलाने का पर्पस था, today we invited some of the faces here whom people otherwise know less, but in fact they are doing more. Rajan ji is one of those faces, Rahul ji and Nupur ji. In fact, they are the one who are not, people are not familiar, but they are doing wonderful work. If you see their product, each and every piece is a different design. And most of the buyers, all major stores like Dilip ji is very well known. So they are very well known for their creation. So you rightly said, अगर ये पहले होता, लेकिन अभी भी कुछ नहीं बिगड़ा. आज सुबह से हमने शुरू किया है, तो आज सुबह से समझिए नई सुबह हुई है, और कोविड के टाइम पर आप इसको याद रखेंगे, तो उसकी एक पहचान.
I want to ask, this is within EPCH members only.
See, right now, because we have to have, say, at least the application is right now within the members, because code of conduct is with the member. But at the same time, Mr. Ankit Sahni just now mentioned that we have an evidence, and this evidence is being done in a very proper manner. Yes, and moreover, now we'll go to the press about the design register. We'll also go to some magazines. We'll also publish in the newspaper about the process. So that means we are going to establish a process. Before coming to this, before finalization of this process, we have already advertised in the newspaper as a stakeholder consultation. So this is now coming to public domain. The moment anything which come to the public domain, and that is being done in a very proper and transparent manner, that becomes the evidence in any court of law. Even if any buyer is going to object you, like I told Mrs. Uma Malik. So suppose a buyer, sometime you develop a design and you develop a product, and then you give it to your buying house or buyer. After 2-3 shipment, he says no. Now, thereafter he started giving on the lesser price to 10 other people. Then he says, okay, you are selling in $10. Then you will find another vendor who will be giving them the same item which were developed by you. It was your creation in $5. So there you can claim, no, this particular design you cannot give. Here is your claim that you can establish. Okay. So, you are smiling right now because this is rightly happening with all of you when we are working with the buying houses.
So I will also encourage this will also encourage healthy competition in the trade, and everyone will be try to give their best. और मुझे पूरा विश्वास है कि हम इस सभी डिजाइन रजिस्ट्रेशन के माध्यम से और EPCH के मार्गदर्शन में इसको भली भांति कर पाएंगे. धन्यवाद राकेश जी.
Thank you, Rajan ji. Thank you very much for your thoughts on the subject. Now we have 7 exporters from across the country who have registered their products on the design register, and some of the exporters have joined us on the panel. We have with us Mr. Tulasi Rao, Mr. K.M. Tulasi Rao from Messrs. Ramakrishna Paramahansa and Company. He is also a member of the Committee of Administration. We have with us, I can see Mr. Rajesh Jain on the panel from Export International Private Limited, Greater Noida. I have also on the screen Ms. Jasmina Jaliang from Heirloom Naga, Dimapur, Nagaland. She is also a member of the Committee of Administration of EPCH. Mr. Anand Jalan is also there from Messrs. Shubham Traxim Private Limited, Kolkata. So I think I've covered them all. May I request K.M. Tulasi Rao, since he has registered his products on the design register, to share his experience with us.
Good evening, sir. Good evening, Rakesh ji, Verma ji, and R.K. Passe ji. Good evening, sir. I am very happy to be with you today in the seminar, Intellectual Property Rights. And I would like to share my views about this design register today. We have to protect our designs. EPCH register is a good initiative. We don't know after this pandemic, we have to be in our business scenarios through online. Most of the sales should be online and through trade phase. There is a scope of copying the designs through online and also through trade phase. So, design register is very prominent initiative by this EPCH today for all these type of product design protection. And we have already registered as a design register member, and we uploaded some products also this morning. It's very easy and it's good for us, for everybody. So in this regard, I would like to give you my experience about intellectual property rights, not only for the larger companies, even for small companies also should be required. I will give you a small example in my experience. About 2007 or 6, we have spent a few lakhs of making one catalog as per my buyer advice. Then my son visited a lot of hotels and lot of designers and making a lot of efforts by making one catalog. So somehow my fellow exporter came to know that we have printed one catalog in some other unknown place. So immediately he got that catalog and he reprinted in his name, entire catalog. And his one exhibition is distributing the catalogs to the foreign visitors. Same, my buyer went to his stand somehow, then he got the same catalog. Then he shocked. Then he came to my stand, Tulsi, then this is your catalog, but that fellow is the same thing. All the products are you, then it's a big problem to me in my country. If you sell your products and he is also selling the same product, it's a big problem. I will stop your orders. Then immediately I shocked and we had a big discussion and blah, blah, blah. And then we came to know that we have decided to take an EPCH decision, help in that regard. I flew all the way from Narsapur to Delhi. Then I sat with our DG sir. Then those days, he guided us. He guided us how to resolve the issue. Then through our association elders, those days we resolved the issue that we were taken from the exporter at those days. That in this regard, what I recommend, design register is a must for all the exporters. I recommend the small exporters and larger exporters also to register, design register under lineage sheet of PPCH. And also, I also recommend that the publicity is required for this design register to know all the people in pan India as well as abroad also. Thank you, sir, for this opportunity given to me. Thank you, Rawatji. Thank you, whole team of design register. Thank you, sir.
Tulsi ji was from the down south, Andhra Pradesh. He was from Andhra Pradesh. We have a center there, Narsapur cluster. And he is a very good host. If you find time, you can go to the Narsapur Lace Center, crochet goods he manufacture. I think, Ravaji, quickly, we bring all of our people, 7 people who are in the different part of the country on the screen. Yes, and show that what they are registering or what they have registered quickly. And a message from, one message from Rajesh Jainji, our social media head. And then I think we have to conclude quickly.
Right, sir.
And there are a lot of question answer. I can see 58 questions are there. Whatever maximum we can attend right now, otherwise we will send them the answer later. Right.
Thank you, sir.
It's a long session today. Yeah. Ravaji, proceed.
Yeah, thank you, Tulsi ji. Thank you very much. Now, may I invite Mr. Rajesh Jain to share his views since he has registered his products on the design register. So briefly, you can tell us, share your experience with us briefly. Or if you can share your screen, how you did it, if you want to do that. It's up to you.
Rajesh ji, basically you have to tell about that, how long it took for you to register your product and how many products you registered just now after seeing this program, this design registration, you had quickly moved on. So how long it took basically for doing that, right?
Sir, Jai Jinendra और good evening to everyone. सर सबसे पहले आपके सवाल का जवाब देने से पहले आपको पता है मेरा अंदाज जरा अलग है, तो मैं सबसे पहले आपको बहुत बहुत मुबारकबाद, कांग्रेचुलेशन दूंगा। सर सपने देखना हर एक के बस की बात नहीं है और बड़े सपने देखना तो बिल्कुल भी नहीं, और बड़े सपने देखकर उसको पूरा करना बहुत मुश्किल है। तो सर ए ड्रीम कम ट्रू, राकेश कुमार जी ने एक सपना देखा और वो आज उन्होंने पूरा करा, वो भी सर कोविड-19 के टाइम में। हम सोच भी नहीं सकते सर, जब इंडस्ट्री को प्रॉब्लम आई है वो राकेश कुमार की तरफ देखते हैं। सर सबसे पहले लकड़ी की जब प्रॉब्लम आई तो आप वृक्ष लेके आए कि भाई उसका सर्टिफिकेशन करना है, चाहो वृक्ष लेके आओ, रात दिन एक कर दिया सर। और आज पूरी दुनिया वृक्ष की कायल है और सारे एक्सपोर्टर भी उसमें जुड़ गए हैं, देखो। और दूसरी जब डिजाइन की मारामारी की प्रॉब्लम आई तो सर आप लेके आ गए डिजाइन रजिस्टर। सर ये सेमिनार से वेबिनार का जो सबसे बड़ा फायदा उठाया है ना, वो आपने उठाया है। न खुद सोते हो न दूसरे को सोने देते हो। हमने तो सुना था कि मोदी जी ने कहा है तुम भैया 30-40 दिन छुट्टी करो, और आप सर हर दूसरे दिन एक नया प्रोग्राम लेके आते हो। तो सर 2.5 घंटे के प्रोग्राम में 2.5 घंटा में तैयारी भी करनी पड़ती है। तो सर सबसे बड़ा फायदा जो उठाया है वो आप जैसे विजनरी ने उठाया है, और मैं बहुत ही गर्व के साथ 250 से ज्यादा लोग जो अभी सुन रहे हैं उनको ये कहना चाहता हूं कि भाई इस इंडस्ट्री में अगर कोई भी प्रॉब्लम आएगी तो मिस्टर राकेश कुमार जो हमारे डायरेक्टर जनरल है सामने बैठे हैं। कोविड-19 सर छोटी प्रॉब्लम है, अगर मैं आज इसको ऐसे विश्लेषण करूं, हमें कोविड-19 के साथ जीना सीख लेना चाहिए।
राजेश जी मुद्दे पे आओ, राजेश जी मुद्दे पे आओ, प्लीज प्लीज मुद्दे पे आओ
सर। ऐसा सर
मुद्दे पे
तो
हो
ये
गया, प्लीज प्लीज, आई थिंक सी इट हैज गॉन लॉन्ग।
सर जैसे ही मुझे सर
नहीं, वो
जैसे ही मुझे
प्लीज, आई थिंक
हाँ सर,
उधर दूसरी तरफ मेरे यहाँ मूवी चल गई है और मुझे उसको ज्वाइन करना है फैमिली के साथ।
ओके सर, जस्ट सर 2 मिनट की बात है जी सर। सर 2 मिनट की बात है कि जैसे ही मुझे रजिस्ट्रेशन करने का मौका मिला सर, मेरे ख्याल से 5 से 7 मिनट लगे मुझे रजिस्ट्रेशन करने में, क्योंकि पहले तो मैं अगर ऑफिस खुली होती तो मैं किसी लड़के को बोलता तुम कर दो, लेकिन चूंकि यहाँ पर सब कुछ करना था तो पता चला मुझे कि मेरा ईपीसीएच का रजिस्ट्रेशन नंबर क्या है वो भी मेरे को मालूम पड़ गया, जीएसटी नंबर मालूम पड़ गया, मेरे को अपना पैन नंबर नहीं मालूम था वो भी मालूम पड़ गया सर टाइप करते हुए, और पेमेंट कैसे करते हैं सर आज वो भी सीख लिया। करते 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 सर डिजाइन को रजिस्टर किया, उसमें साइज, उसके अंदर में कलर और ऊपर नीचे, मतलब सर एक बहुत ही अच्छा लर्निंग एक्सपीरियंस रहा सर। 5 से 7 मिनट लगा, बहुत ही इजी है, और सर पेमेंट भी कर दी और रजिस्टर भी कर लिया हमने। और मुझे लगता है अभी हमने एक ही रजिस्टर किया क्योंकि हम देखना चाह रहे थे कि इसकी रूपरेखा क्या है, लेकिन सर 1 करो या 10 करो, तो मैं सर बहुत बहुत मुबारकबाद देता हूँ ईपीसीएच को, डेफिनेटली कमिटी ऑफ एडमिनिस्ट्रेशन को, चेयरमैन साहब, वाइस चेयरमैन साहब को, और यहाँ पे जितने भी लोग उपस्थित हैं जिनको सर आपने एक डोर से जोड़ा है ना, मजा आ गया सर। अब डिजाइन कर लेंगे हम रजिस्टर। सर आपको एक बात और बता दूं जाने से पहले, पिछले 20 दिन में सबसे ज्यादा डिजाइन हमारे डिजाइनरों ने घर में बनाया है। करें क्या, पैसे अगर लेने मेरे को डिजाइन बनाओ, तो सर 500 से ज्यादा डिजाइन हम बना चुके हैं और मैंने पैसे भी जमा कर दिए हैं। तो मैं कल सबसे पहले काम करूंगा सर, डिजाइन को रजिस्टर करूंगा। सर बहुत बहुत धन्यवाद, थैंक यू वेरी मच, और दिस इज अ गोल्डन अपॉर्चुनिटी। कंग्रेचुलेशन सर।
चलिए आपसे शेयर कर दें, 3rd बेस से पहले 2 चीजें आप सब लोगों के लिए और आ रही हैं। एक, हम कोविड-19 अकेले कोविड-19 पर नहीं, लेकिन जितने भी वायरस हैं उनके ऊपर हम लोग एक सेफ्टी कंप्लायंस हम लोग तैयार कर रहे हैं जिसके स्टैंडर्ड बन चुके हैं। और ये कंप्लायंस का सिर्फ एसओपी नहीं है बल्कि इसमें पूरा सर्टिफिकेशन है। मतलब ये सर्टिफिकेट आप किसी भी जगह दिखाएंगे, सब जगह ये वैलिड होगा। एक ये काम हो रहा है, और दूसरा काम हो रहा है वर्चुअल फेयर का। वर्चुअल फेयर की जिसकी हम बात कर रहे थे, ताकि इस बार अगर हमने फेयर अप्रैल मिस किया है तो आपको ऑफिस ज्वाइन करने से पहले कोशिश करेंगे आप सब लोग वर्चुअल ऑनलाइन ट्रेड फेयर में आ जाएं। इस पर तैयारी वर्मा जी बहुत कर रहे हैं, वर्मा जी उसमें काफी लगे हुए हैं, हमारी बाकी टीम भी पूरी इसमें लगी हुई है, हमारी सीओए और हमारे चेयरमैन साहब, वाइस चेयरमैन, आप भी सब लोग उसमें मेहनत दे रहे हैं। हम उसके बारे में बाकी आपको डिटेल देंगे। रावत जी प्लीज टेक इट फॉरवर्ड।
Thank you, sir. Thank you, Rajesh ji. Thank you very much for those very, very encouraging, very vibrant and very words. Now we have with us Jasmina ji, Jasmina Jiliang, who has joined us from Nagaland. She is a member of the Committee of Administration of EPCH and a woman entrepreneur from northeastern part of the country. Jasmina ji, quickly you can share how you have registered, how many products you have done that, how long it took for you to get yourself registered on the design register. Jasmina ji, you have to unmute yourself. You have to unmute yourself. Yeah.
I've done that.
Yeah, we can hear you. We can hear you.
Okay. Good evening, everybody. I think today is a historic day for all of us, and especially for me. I call it a historic day for me on 3 counts. 1, as a designer for the products that I create. 2, as a producer, and 3, as a businesswoman. And in the same breath, I can't begin to express how delighted and excited I am to be secure in the knowledge that finally my products are being protected by unscrupulous practices. When I say practices, it would be my competitors, or in a very crude manner, I will say copycats. how comforting is the thought that my designs are being protected now. No doubt, I had the facility to go and patent my designs, but if I have to speak for myself, since I'm constantly updating my designs, it was not feasible, to say the least. And for a very long time, I consoled myself by telling myself that imitation is the best form of flattery, because I could not do anything much. But believe me, there were many instances where I really wanted to drag my so-called copycats to court. But sincerely speaking, who has so much time and energy or resources or the wherewithal to do all that? So today, I'm feeling so secure and comfortable in the knowledge that my designs are being protected by EPCH. And here, I would like to share a small incident that I also experienced when I was an exhibitor. So this was about 5 years back, when one of the buying agents had come to me and chose one of our designs for a very renowned chain of stores and a catalog company called West M in the US. All the designs was original designs. It was the designing, the colors, everything was ours. We went back and forth in developing the designs. And after, there was a very long spell of silence, and I asked the buying house, what happened to my designs? They came back to me saying that, well, it was very expensive. And the next thing that I see, when one of my friends had gone to the US and brought a catalog, I see one of my designs which was randomly copied in Panipat. Now, this is the kind of unscrupulous practices that also happens in the trade. And today, I believe that this initiative and service that EPCH is bringing to us is remarkable. So thank you so much, Team EPCH, for protecting us from all those unscrupulous practices or copycats, I would say. Before I end, I just read about what Mark Twain had famously said. He said that there's only one thing which is impossible for God. I repeat, only one thing is impossible for God, which is to find any sense in any copyright law on the planet. This is Mark Twain who famously quoted this. But I know that EPCH, with all its proactive initiatives, will help all of us to be secure in our copyright initiatives. Thank you very much.
Thank you, Jasmina ji. Thank you very much. As always, we have words of wisdom from your end. Now we have two more speakers to speak on. We have Mr. Anand Jalan, who will share his experience with Design Register. And we also have with us Mr. R.K. Verma, Executive Director, EPCH. So I'll start with Mr. Jalan to quickly share your experience, and then we'll move on to the question answer session, because Mr. Ankit Sahni is ready with answers. So Mr. Jalan, quickly you can share your experience, then we can.
Yeah, Mr. Jalan is from Kolkata.
Yes, sir. Good evening, everybody. Good evening, everybody. It was a very holistic approach given by Mr. Sahni. Another feather in the cap of Rakesh Kumarji and team EPCH. I congratulate Rakesh Kumarji and the entire team of EPCH, and we are again fortunate enough to learn something very new from our council. And I hope it is just a beginning, and we'll go a long way in this ethical and morally binding approach from our council. Thank you.
Thank you, Mr. Jalan. Thank you very much. May I now request Mr. R.K. Verma, Executive Director, EPCH, should share his thoughts on the subject and also on the Design Register, the initiative that EPCH has taken. Mr. Verma.
रावत जी, थैंक यू. मेरी बैटरी खत्म होगी, मैंने चार्जर लगाया, तो मैं अभी आईफोन पे बात नहीं कर पाऊंगा क्योंकि बहुत लंबा सेशन हो गया. फर्स्ट ऑफ ऑल, थैंक यू. इट्स अ वेरी आई कैन से as all the speakers have given a positive response to our EPCH initiative, definitely this will create a confidence amongst all the members of the EPCH, and they can with the confidence display their products. The companies, those create own design, will definitely will get the confidence, and those will basically copy their design. They will definitely not come to the very clearly or openly display their products. So it will be a protection for our member exporters who will be devoting the time for the creation. So I think as a new chapter begin with the EPCH and members' confidence, and likely tomorrow we are sending a complete details to all members how to register in the design register. So thank you very much.
Thank you, sir. Thank you very much. Now, may I request Mr. Sahni to take up question and answers, because there are a lot of them, and you can start answering those questions. Mr. Sahni.
Thank you so much, Rawatji. I will try to address as many questions as possible, but I will here wait for your bell. As soon as Mr. Rawat's bell goes, then time is up, and I will be happy to answer these questions over email or call. I've already shared my email. So I'm starting from the very beginning, the first questions that we got. I'm seeing one that says a lot of times we get products or products pictures with specifications from our buyers. To reproduce it, we don't know if that product is copyrighted. We make the same and land up in trouble. What should be done? So one of the things that we discussed, of course, was as a good practice, because it's not possible to do due diligence and to check if a particular design belongs to a person, a company or not. The right way is to protect ourselves. Whenever we enter into a contract, we should at least agree to in writing for an indemnity clause, which basically says that if there is any design that our client wants us to make, if that design belongs to somebody else, and if that somebody else sues us, whatever damages or whatever inconvenience we have made to put through, our client will indemnify us and keep us essentially compensated for all the loss. So this is the easiest way to take care of this kind of risk, and by entering into an agreement. The next question says, if we have done copyright of some item after some exporter developed the same sample and did some minor changes in embellishment in the base or the shape, but some of the elements are the same, then what do we do? So copyright doesn't just, or for that matter, design, let's talk about design. So designs or copyright doesn't just protect the exact shape or base or embellishment of your product, but it also covers anything which is deceptively similar to your product. So anything which appears to be on a first glance inspired by, heavily inspired by, and copied from your registered copyright or design, you can definitely take action under law. The next question is, what and how will a person be penalized if a person is caught copying a design during the trade fair and it is proved by registration? Okay, so there are two kinds of remedies which are available under law. It is a criminal offense to copy somebody else's registered copyright. There is imprisonment up to 3 years along with the fine. You can get arrested, you will have to apply for anticipatory bail. That is on the criminal side. On the civil side, they can, the owner of the copyright can sue for injunction to stop you, injunct you from using their design, as well as claim damages. So whether this is done during a trade fair or after a trade fair at any point in time, if it is copied and it belongs to somebody else, it is wrong. Moving on to the next question. Okay, another question. If I'm a member of EPCH and my design is copied by someone who is not a member of EPCH, will there be any action on it? I will leave this for Rakesh ji to answer this particular question in case he's available. I'll move on to my next question, which is how do we protect our traditional designs and traditional processes apart from GI? So, the very nature of traditional designs is that it has existed in our society for several years. It belongs to the community, the artisans who make it. Therefore, there is no possibility of any individual or any company, etc., from essentially, monopolizing what is traditional, what Rumaji referred to as an open design, and is available to all to take benefit from and to utilize in our various products. So there is no law that will help you protect what doesn't belong to you. You can only protect what belongs to you and you have created. So to that extent, apart from GI, you won't be able to monopolize a traditional design. Then the next one, does copyright protect design or cuts of a ready-made garment? Yes and no. Yes, because if there is a shape of a particular garment and it is unique to the extent that it meets the benchmark of originality or novelty which is required under law, it will be protected. No, because I'm putting a caveat. We discussed about Section 15 of the Copyright Act that says if a particular thing could have been protected as a design but you did not, then for machine-made garments, it will be limited to 50 pieces and not beyond that. The next question is, GI itself is a community-owned IP and protects the entire community. Can a person register a GI for registered products or copyright? Does copyright protect second layer? Okay, so GI, yes, it is a community-owned right, and therefore members of a community are entitled to call what they make as the name of that particular GI. GI is not just limited to Indian goods. Under Indian law, you can also register GIs that belong to other countries. One popular example is Scotch whiskey. So whiskey which is made in Scotland, of course, as we all know, is Scotch whiskey, which is protected. So it is owned by the community, not by a particular individual. So you cannot monopolize as an individual. Is it possible, next question, is it possible to register a brand in one place for the whole of Gulf or Saudi Arabia and also in one place for Africa? Yes, there is an association of various Middle East countries. Similar system is also in place for Africa called OAPI. So these countries work. The third system which is in place is EU IPO. So these three bunches of countries would allow you to get a single registration which will cover all member countries of such organizations. So EU TM, EU trademark will give you protection over trademark in each of the member countries. Same for Gulf, same for Africa. Is there a copyright and trademark registry or depository? Yes, I mean, if by this question Mr. Chavda means that is there a register or a database where this is maintained? Yes, the database is publicly available. It is available on the IP office site, which is ipindia.nic.in, and you don't need a lawyer to search the copyright or trademark registry if you need to search for a similar trademark or copyright. Okay, so additionally, how do copyright or cultural IP rights work when a designer works alongside an artisan to recreate a craft which wasn't created by the designer? Okay, so this is a very interesting question. There are two peoples or two communities' rights at stake here. One belongs to the artisan, the other belongs to the designer. So I will try to simplify the answer and say, to the extent that the product of the joint effort of the artisan and designer results in something new, which cannot be simply written off as traditional design, it will qualify as something which is an IP right, subject matter protection, either under Copyright or Designs Act, as the case may be. Since both the artisan and the designer have worked on it, both should be entitled to ownership. But like we discussed, ownership is a subject matter of contractual relationships, if you like. Neither the designer nor the artisan, being employees, should have ownership of the right. The ownership can vest in the business that employs the designer and the artisan. Difference between, next question, difference between trademark and R, register, TM and registered. Okay, so TM, when you see that written above a trademark, that basically refers to the fact that it is an unregistered trademark and the person who writes TM wishes to tell the world at large that they are utilizing that phrase or that logo as a trademark, just to tell the world they're using it as a trademark. And when you put R in a circle, so you're only entitled to put R in a circle when your trademark gets registered. If you put R in a circle over a trademark which is not registered, there is a penalty for it, which also includes imprisonment. So we would advise everybody to refrain from using R in a circle unless they've got a trademark registered by the IB office. Okay, next question. According to you, it takes 6 to 8 months to register a design. It is practically not possible for an ethnic garment designer to wait for such a long period of time. Okay, so yes, design process takes long, but to tell you, we are, even 7 years ago when we were dealing with clients 8 years ago, it used to take much longer. Many of you who have already invested time and resources in getting designs registered would recall it used to take 3 to 4 years, even more, to get designs registered. As a result of this government's initiative, now it takes 6 to 8 months. This is by and large at par with what is the time taken by most developed countries as well. So to put it simply, the way to look at a design registration is not that you will have to wait for 8 months. See, the moment you file a design and start working, start commercializing your design, you can start making it public. The only thing is that your right gets realized or gets fructified only at the end of 8 months when it gets registered. So your right gets protected from the day you apply for it, but the registration comes into effect from the day you're awarded a registration certificate. So those 6 to 8 months are not wasted, but you can take action once your design gets registered. And hopefully that answers your question. Moving on, a lot of exporters, designers copy designs from Pinterest. Will that fall in copyright infringement? Yes, it will fall in copyright infringement, whether we use Unsplash or we use Pinterest or we use any other website where people upload their pictures. Just because it's available in the public domain does not mean that the people have necessarily allowed for it to be appropriated and commercialized by you. There are various resources available on the internet that will allow you to borrow images and designs in an open manner. Again, going back to what Rumaji said, those are open pictures or copyleft pictures, but sometimes they will require you to, at the very minimum, acknowledge them as the designer, and then there will be no further sort of restriction on you using those designs for commercial purposes. So you have to be very careful on where you take a design from. Easiest thumb rule is always presume whatever you haven't created and you're copying from somewhere else belongs to that person, and they will take action against that. Next question. As a retail business works on following season colors and trends or designs and color themes sold by top brands, how to protect ourselves? What are the minimum different characters that will help us protect? Okay, I'm sorry, the question is not very clear, but if I've understood it correctly, if you would like to protect combination of colors, yes, combination of colors can be protected as long as there is some originality, or if you can prove that you were the first ones to use the combination of colors, and there is some basic level of creativity, basic benchmark of creativity and effort that has gone into making what you've made, you can to some extent claim protection over combination of colors as well. Next one is, assuming we make less than 50 pieces of particular product, in which case we have both copyright and design right options, which is more cost effective. Okay, to clarify, you will not have both copyright and design right options only because you're making less than 50 pieces. Design right options exist only as long as your design is not published or has not been disclosed to the public at large. Therefore, if you apply for a design before you publish it, you will get a design right. In such circumstances, you will have both design right and copyright, and it will be for unlimited number of pieces as long as the design right exists for a period of 10 plus 5 more years, 15 years. However, if you miss the opportunity, miss the bus of getting your design right registered under copyright, again, this question doesn't mention if you will be reproducing using machine or industrial process or using hands. If it's through industrial process, then your right will remain restricted to 50 pieces. The moment you create a 51st piece, the right becomes open to public and open for everybody to copy the design. But if you're using a handmade, purely handmade process, then in that case, that 50 pieces restriction does not exist. Okay. Link to get registered. Okay, now I think more questions are directed at Rakesh ji and his team regarding the design register.
I think, Ankit ji, you have already answered most of the questions. There are some of the questions like one question that I've seen is asked frequently by many people that if there's a design already registered under some copyright or patent act or maybe under some design registration act outside, then EPC design will be valid or not. In that case, definitely the design registered under the patent act, but prior to the date of our design register will supersede that. In case the design comes after our date, that means already somebody has registered in the design register, and then later to that date somebody has applied for the design register, applied for the copyright or patent act, then we will contest for them. That means that design already existed and we already have. That means the design already existed and that was produced by our member. So we would definitely take it for a contest. Second,
just to add to what Rakesh ji is saying, there is also a process under law to cancel a registered design. And that can be, that option is available to everybody if they can prove that the person has wrongly got the design registered. So that option is there.
Even the design has been patented by somebody, we can request that should be cancelled because they give an affidavit over there. The design has been produced by me and nobody else. So then we can prove that no, it has been produced by X person. Now the second question is that suppose two persons have produced the same design and they have registered on the design register. Then certainly the person whose date and time is the previous one in two designs, that will be the valid design because he has come as the first to the design register. That means he produced it, and the second one who registered later on, he copied it. So it's advisable the moment you produce the design, you have to register the design. Or if you think that okay, now we are going to have commercially exploit this design, certainly you have to immediately get the design registered. Otherwise, how the other person will come to know that similar design has been produced? Even there was an example that the two twins can also have a absolutely same. They can have a similarity but not same. So two design cannot also not be the same. So I think you have to take that advantage. And first, you immediately have to register a design. One question was, what do you mean by rupees 10? The rupees 10 means per design, the design registration cost is only rupees 10. And there's a value available there, and the value you can use that value so that you can pay out of that. So there are not much questions. Whatever questions are there, we'll definitely reply to all 300 members who are participating at the moment, and we'll send them later on. Thank you, Rawatji. Please take it forward.
Yeah. Thank you, sir. Thank you very much. And thank you, Ankit for all the questions. You have taken a lot of them. And we have a manual for this design register, which is also there when you register. So you'll get all your answers from there. Now, we have come to the end of this very wonderful session that we had. We had a marathon 3-hour session today. And I would like to thank all the panelists, the expert who has joined us in today's discussion. And I would like to share with you one piece of information that we today have the maximum participation, and we have crossed at one point. There were 300, more than 300 participants. That is an overwhelming response that we have got. And I thank all of them for joining in this webinar. Thank you once again. Thank you very much. And we'll let you posted with the next webinar session that we intend to organize in the coming. Thank you once again. Thank you very much.
आप रावत जी बस इनको एक किस पर रजिस्टर होंगे, वो जो आपकी वेबसाइट है वो डिटेल दे दीजिए. Please give the details of the website on which this is to be registered. Online website.
सर कल एक मेल जा रही है.
कल मेल जा रहा है.
सर उसके अंदर पूरा डिटेल, पूरा उसका लिंक भी होगा, वेबसाइट भी होगी.
ठीक है. ओके.
पूरा प्रोसेस होगा सर उसमें.
फाइन. थैंक यू. ओके. थैंक यू.
ओके. Thank you very much. Okay. Thanks. Okay. Thanks.
Thank you, Ankit ji. Thank you very much, Ankit ji. Thank you all the panelists again. Thank you, Jalan sir.
Thank you, sir.
Rajesh Jain ji, Tulsi ji, our Jasmina ji, Ravi Pasti ji, especially our chairman who waited for 3 hours. Thank you very much, everybody, all the participants. Thanks.